A very good afternoon to you. Glad you are watching KBC Channel 1. It is Tuesday, the 10th day of the month of March. The year is 2020. And you are in time for live proceedings from the National Assembly this afternoon. Quite a number of bills listed for debate and motions as well. And first things first, members shall be putting the question to a bill that they have discussed at length. It is the Business Laws Amendment Bill, National Assembly Bill number 80 of the year 2019. And it is intended to amend various statutes for the purposes of facilitating the ease of doing business in the country. And this afternoon, members shall be deciding whether they will be making amendments in the next stage if they approve it, which will be in the Committee of the Whole House. Two bills scheduled for amendments this afternoon in a Committee of the Whole House. The first will be concerning the Law of Contract Amendment Bill, National Assembly Bill number 1 of the year 2019, that seeks to amend the Law of Contract Act, Cap 23, so that in case of a default by the principal borrower, then the creditor will first realize the assets of the principal borrower before proceeding to release assets of the guarantor. This bill was approved by the House, forwarded to the President for assent. Rather, he did not assent to this particular bill. He has returned it to the House with some reservations, and he specifically wants Clause 2 of this particular bill deleted, and it speaks to a suit that will be brought against a defendant, that the plaintiff shall first realize assets of the principal, and that for avoidance of doubt, it shall not be applied retroactively. The President has made a number of observations, including and notwithstanding that the proposed amendments were reintroduced prematurely. The provisions contained in the bill were originally contained in the Statute Law Miscellaneous Amendment Bill 2019. He also notes that proposals in this particular bill will negate a long-standing principle of contract law that is relied on by lenders, borrowers, guarantors, investors, and other stakeholders in the Kenyan economy, especially the capital markets. The head of state also notes that this proposal will adversely affect credit advanced to micro, small, and medium enterprises due to lenders' reluctance to rely on third-party collateral. The other bill that shall be coming before the Committee of the Whole House is the Representation of Special Interest Groups Laws Amendment Bill, National Bill number 52 of the year 2019. That seeks to amend various existing laws in order to give effect to Article 100 of the Constitution, that seeks to promote a legal representation in Parliament of women, persons with disabilities, the youth, ethnic, and other minorities. A live broadcast brought to you by the Parliamentary Broadcasting Unit in conjunction with the Kenya Broadcasting Corporation. My name is Vereso Mwanga. On behalf of the entire crew, I welcome you to follow this afternoon's broadcast. Enjoy.
Let us pray. Almighty God, who in your wisdom and goodness have appointed the office of leaders and parliaments for the welfare of society and the just government of the people, we beseech you to behold with your abundant favor as your servants whom you've been pleased to call to the performance of important trusts in this republic. Let your blessings descend upon us here assembled, and grant that we treat and consider all matters that shall come under deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the peace, prosperity, and welfare of our country, and of those whose interests were committed to our charge. Amen. may start.
Order number 1, administration of oath. Order number 2, communication from the chair.
Honourable members, as you're already aware, the week started off on a very sad note for the National Assembly, in that the residents of Kwale County, and indeed the nation as a whole, following the demise of Honourable Suleiman Dori, Ramadan MP, member from Msambweni. The Honourable member passed on in the morning of yesterday, Monday, the 9th of March 2020, while undergoing treatment at the Aga Khan Hospital, Mombasa. Honourable members, the late Honourable Suleiman Dori Ramadan was born on the 19th of October 1977 and attended Tudor Secondary School and later other institutions, including the Young Men Christian Association, YMCA Mombasa, where he was trained on community development. Honourable members, the late Honourable Suleiman Dori's parliamentary career commenced in March 2013, following his election by the people of Msambweni constituency, Kwale County, as their representative. Subsequently, following an active and successful first term in the 11th Parliament, the people of Msambweni again voiced their confidence in his leadership, re-electing him to this August House in August 2017. During his first term in Parliament, the Honourable Suleiman Dori, and an illustrious career as a member of the Departmental Committee on Lands, as well as the Departmental Committee on Transport, Public Works and Housing, where he contributed immensely to the work of the two committees. He rejoined the Departmental Committee on Transport, Public Works and Housing in the current Parliament and has been serving as a vocal and dedicated member of the committee. He was particularly active during consideration of bills, petitions, and parliamentary questions in the committee, as well as during vetting of nominees to various state and public offices. You will recall that during the consideration of the Statute Law Miscellaneous Amendment Bill 2019 in July last year, he was very active during the debate on the amendment to the Merchant Shipping Act. Honourable members, the Honourable late Dori was also an active and influential member of the Coast Parliamentary Group, where he was the chairperson as well as the former deputy organizing secretary of the Orange Democratic Movement. Honourable members, the late Honourable Suleiman Dori was committed to the economic empowerment of farmers and strongly supported a motion seeking the government's financial support and relief to cushion coconut farmers in the coastal region, as well as the proposed inclusion of coconut insurance under the National Agricultural Insurance Program. He was also vocal in supporting calls for the national government to consider giving regular honoraria to village elders as a means of appreciating their services and encouraging them to uphold their dedication to the community. As a passionate advocate for use of Kiswahili in the House and other public institutions, the late Honourable Dori was instrumental in calling the National Council for Law Reporting to progressively translate all laws of Kenya into Kiswahili, and indeed the now realized translation of our standing orders into Kiswahili. Honourable members, the late member was very pragmatic in his approach to leadership, which was highlighted in many occasions, including during debates on security issues, in which he once said the following during debate in the House, and I quote, "Ni jukumu letu kama viongozi kuhakikisha tumelinda Wakenya. Tusije hapa kila wiki ikawa tunazungumzia mambo ambayo hayaleti mwelekeo wowote kwa Wakenya. Wakenya wametuchagua, Wakenya wana imani na viongozi na ni lazima tuwatendee kazi Wakenya wote. Close the quote. Honourable members, the late Honourable Suleiman Dori was a dependable leader who served his constituents with utmost commitment. He was selfless, ambitious, realistic, resourceful, and committed to public service. Without doubt, honourable members, the residents of Msambweni constituency, Kwale County, this House, the entire Parliament, and the nation at large have lost a vibrant, pragmatic, and dedicated leader. The member was laid to rest yesterday in Msambweni in accordance with Islamic tradition. May God rest his soul in eternal peace. Honourable members, in tribute and honor to our departed colleague, the late Honourable Suleiman Dori Ramadan, MP, I request that we all stand to observe a moment of silence. May his soul rest in eternal peace. Members making your way in, please. Members who are making their way in, please take your seats. You can take your seats temporarily for the time being so that I can... Honourable members, the Kenya National Commission on Human Rights Amendment Bill, National Assembly Bill number 1 of 2020, was read the first time on 27th of February 2020. Starting under 127, subsection 1 provides that a bill, having been read the first time, shall stand committed to the relevant departmental committee without question put. Despite the said provisions, starting under 127, subsection 6, paragraph A provides that the Speaker may direct that a particular bill be committed to such other committee as the Speaker may determine. Honourable members, I have since received a request to determine the suitable committee to consider the Kenya National Commission on Human Rights Amendment Bill, National Assembly Bill number 1 of 2020. The bill seeks to amend the Kenya National Commission on Human Rights number 14 of 2011 in order to merge the Kenya National Commission on Human Rights and the National Gender and Equality Commission. Part 5 of Chapter 5 of the Constitution, particularly Article 59, Clause 5, provides as hereunder, and I quote, Parliament shall enact legislation to give full effect to this part, and any such legislation may restructure the Commission into 2 or more separate commissions. Close the quotes. Honourable members, this particular bill is published following lessons learned and challenges experienced during the implementation of the Constitution. You will recall that the Kenya National Commission on Human Rights and Equality Commission, established under Part 5 of the Constitution pursuant to the provisions of Article 59(4), was split to create 3 independent offices. That is the Kenya National Commission on Human Rights, the National Gender and Equality Commission, and the Commission on Administrative Justice. As you are aware, the Constitutional Implementation Oversight Committee, established under the 6th schedule to the Constitution, is responsible for overseeing the implementation of the Constitution. Given this background, the Constitutional Implementation Oversight Committee will be valuable in reviewing the lessons so far learned in the journey to implement the Constitution. Honourable members, I therefore direct that the bill stands committed to the Constitutional Implementation Oversight Committee to discharge the functions specified under Standing Order 127, subsection 3, and section 3A relating to public participation. It is so directed. I thank you. Next up. Which one? No. On Doris. Honourable members, I notice that there are some interventions. Honourable Leader of Majority.
Mr. Speaker, I, on behalf of my family, myself, and the people of Garissa Township, I want to take this opportunity to send my sincere condolences, despite with the Leader of Minority and other members representing you and the House yesterday at the funeral, the burial of our colleague, departed colleague, the Honorable Suleiman Dori. I think he has joined the list of our colleagues who are in this session, also who went to live with the Almighty God, the Honorable Nyenze, the Honorable Ken Okoth, and Honorable, yes, and Grace Kipchoin. The Honorable Suleiman was a very good leader. And one thing I can remember for him was that he used to agitate for the people of Msambweni and Kwale in general, mainly on land issues, mainly on matters, you remember the titanium mining issues and the community conflicts. And I'm sure that is a route each one of us is heading. Because in the Holy Quran, it said, all lives will test death. So it's something imminent. We only don't know when and how it will come. But I'm sure as colleagues, there is something that we usually do for the family of one of our colleagues when he departs. Myself and the Honorable Leader of Minority will do a joint letter to the clerk, so that, Mr. Speaker, whatever we collect, you will look for a date so that when we can now, as a House, we can see the family under your leadership. So, Mr. Speaker, my condolences to the people of Kwale, and I'm sure, particularly his family, his young family. He had a young family, 2 children of 6 and 4 years old. That's a very young family. And we pray that that family gets strength during this difficult moment. And of course, the people of Msambweni. Thank you, Mr. Speaker.
Asante sana, Bwana Spika. Kwa niaba ya familia yangu na watu wa Kimilili Constituency na Trans Nzoia County kwa jumla, ningependa kuleta rambirambi kwa familia mwenda zake Mheshimiwa Suleiman Dori, ambaye alikuwa rafiki yangu wa karibu. Tunamkumbuka Mheshimiwa Dori, alikuwa mpole na alikuwa mstaarabu. na tunaomba Mwenyezi Mungu abariki familia yake, aipatie nguvu wakati huu mgumu, Mr. Speaker. Tunaombea watoto wake, tunaombea na mke wake, kwa sababu tunajua wamelia sana, lakini tunaomba Mwenyezi Mungu awapanguze majonzi. Asante sana Mr. Speaker.
John Badi.
Thank you very much, Mr. Speaker. Mr. Speaker, also on my own behalf, that of my family, my constituents, the leadership of minority side, more particularly the Orange Democratic Movement Party, on whose ticket Honorable Dori represented the people of Msambweni for close to 7 years, I think 7 years, if not more. I want to register our deep condolences and sorrow for the demise of Honorable Suleiman Dori. Mr. Speaker, we got news of Mr. Dori's death very early in the morning, around 6. In fact, it is my party leader who called me to tell me that we had lost our member, Honorable Dori, and I immediately reached out to you. And Mr. Speaker, as a party, it's a great loss to us, and I want to register our sympathies with the people of Msambweni who have lost their leader and who have lost a committed leader. Mr. Speaker, the leader of majority and other members, a good number of members, managed to attend this funeral. And given the time it took between the time when Dori died and the time of his burial, it was amazing to see a large number of members of parliament from across the country, Mr. Speaker, who made sure that they were there and struggled really to reach there. So, Mr. Speaker, that showed and demonstrated that Dori was a friend of many and a friend of almost all of us. Mr. Speaker, I just wanted to say on behalf of the party that I know that there was a period in time that our party disagreed with the late Honorable Dori. But this is a member of parliament who a member of our party, who even after disagreeing with the party, came and consulted with us and followed the due process, and later the party pardoned him and he was forgiven. And Mr. Speaker, that we did procedurally through the National Executive Committee of the party, Mr. Speaker, as a party that respects rules and procedures. And so, Mr. Speaker, we hope and pray that the people of Msambweni will have peace, and even as they seek replacement for Dori, they will do it in peace, and they will get a person who will fit in the shoes of Honorable Dori. I want to thank you, Mr. Speaker.
What is this outfit? Honourable members, before I give the next few members to condole with the family, allow me to recognize the presence in the public gallery of pupils from the following institutions. 1, Mwiki Primary School, Ruiru Constituency, Kiambu County, and those from Arab Moi Primary School, Kajiado North Constituency, Kajiado County. Ole Sankok.
Thank you very much, Honorable Speaker. And on my own behalf, on behalf of my family, and on behalf of 6.5 million Kenyans with disability, I want to send my heartfelt condolences to the family of Honorable Suleiman Dori. Honorable Speaker, he was a great leader, and I can only say that let him fly with the angels, because he's one of them. Honorable Speaker, and next time when we have such issues, Honorable Speaker, even for those of us who are well-known professional mourners, we should respect people's cultures, beliefs, and religion, so that we don't introduce politics in such occasions. Thank you very much, Honorable Speaker. May his soul rest in eternal peace.
Honorable Millie Odhiambo.
Thank you, Mr. Speaker. I wish to take this opportunity on my own behalf, on the behalf of my family, and the behalf of Suba North, to convey our condolences to the family of Honorable Suleiman Dori and to the people of Msambweni and Kwale for the loss of a very good member. Mr. Speaker, we served with them in the last parliament and the current parliament. And Mr. Speaker, I know sometimes as members, people go through different things and we don't know. I used to greet him here many times, and I noticed he had reduced, he had lost some weight, and I just assumed he was working out. Mr. Speaker, I want to say that it is good that even as we are eulogizing him, we can say some of the good things that he has done for his constituents. I think it is a reminder for each one of us that even as we pass through here, we need to remember what is our purpose as we come in this house, and that we should always remain true to our purpose, because at some point, you will face your maker. And what will we remember you by, Mr. Speaker? Mr. Speaker, I want to say that our brothers, our Muslim brothers, give us a lot of challenge. You know, our brother died in the morning, and before some of the members even heard, he was already buried. It's both traumatic, but yet at the same time, it is very fast and shows the realities of life. And check, Mr. Speaker, we are here today continuing and going on with our lives. And that takes me back to the issue that I'm saying, that let each of us consider our purpose even as we serve here. With those few remarks, Mr. Speaker, I convey my condolences.
Member for Makueni.
Thank you, Mr. Speaker. Mr. Speaker, on my behalf, on behalf of my family, and on behalf of the people of Makueni, wish to condole with the family of the late Suleiman Dori. Mr. Speaker, Mr. Dori was a personal friend, and in fact, he recently lost his father while both of us were traveling, and we traveled back to Mombasa when he was able to rest his father, and he had young children. He was very hardworking, he was kind. Recently, I was with him at the CDF office. He was following up the projects of his constituency. Mr. Speaker, he dealt with quite a number of issues which touch his constituents, and in his constituency, Mr. Speaker, there lives all Kenyans, from all regions who have gone to settle in that constituency, and he was able to serve all of them equally, including the Kamba community which lives there. Mr. Speaker, we want to say that he is a leader to be emulated by many, and we hope that the people of Msambweni will elect another leader who is as faithful and who is willing to serve the way the Honorable Dori served his generation. I thank you, Mr. Speaker.
Chairman of the Transport Committee.
I thank you, Honorable Speaker, for giving me this opportunity. And I want to say again, as our colleague said, on my own behalf of my family, the great people of Pokot South, and the great members of my committee of transport, where the late Dori served, Honorable Speaker, I would like to pass my condolences to our past colleague. Honorable Speaker, in our committee we will lose a great contributor and a great man who in every time, Honorable Speaker, in the committee, he is very active. Honorable Speaker, and when he's not even in the committee, he can be felt that he's not in the committee. Because when he's in the committee, he makes very valuable contribution. And a case in point, Honorable Speaker, that when issues of the great people of Coast happen to be before the committee for discussion or adjudication, Honorable Speaker, Honorable Dori was number one. And in this country, Honorable Speaker, has lost a great man. Even some of us in the same committee, when he was being disturbed by the other side, we were wondering how can people disturb such a gentleman and a diplomat, Honorable Speaker. So actually, death is very cruel, Honorable Speaker, that we have lost a great man. And we pray that wherever he goes, that he goes to rest in eternal peace. And I take this opportunity, Honorable Speaker, to thank the Office of the Clerk. When I received the news yesterday morning, and I was away and engaged, Honorable Speaker, I managed to get to the clerk's office to facilitate my members who represented my committee very well, led by Honorable Mogaga Kemosi, and Honorable Hassan, Honorable Bashani, and Absalan. Honorable Speaker, my members were facilitated immediately. And I think this should be the spirit, Honorable Speaker, that you should find an opportunity where the Office of the Clerk can respond quickly on issues that affect the people, and particularly, Honorable Speaker, that are emergencies. My committee appreciates the Office of the Clerk. But with those few remarks, Honorable Speaker, I pray that our colleague may rest in eternal peace. I thank you, Honorable Speaker.
Member for Kisumu East.
Thank you, Mr. Speaker. Mr. Speaker, on my own behalf, my family, on behalf of the constituents of the great constituency Kisumu East, and more so on behalf of APNAC, the African Parliamentarians Against Corruption Kenya, of which Honorable Suleiman Dori was one of our main members. We want to send our condolences to the family of Mheshimiwa Suleiman Dori, his constituency, and the people of Mombasa. Of Kwale. He was a great man and a very humble leader, and the interaction that I had with him, not only in APNAC, but also in the Muslim Parliamentary Caucus, has enlightened me quite a lot about the ability of this great leader. We shall miss him, and we pray that, inshallah, Almighty God will give him peace in heaven. Amen. Thank you.
Finally, the Deputy Speaker.
I thank you, Honorable Speaker, and also on my behalf, and most importantly on your behalf, Mr. Speaker, because I know you seated there. It's very difficult to say what you wanted to say, particularly in a debate like this, Mr. Speaker. I would like to also send my condolences to the family of our late colleague, Suleiman Dori. Mr. Speaker, Dori, when he served in this parliament, was one of the active members, both within and outside. Mr. Speaker, you remember at one point, he was the chairperson for the Coast Parliamentary Group. That is to say that he was a well-recognized leader, both within this parliament and even back at home. So, Mr. Speaker, I take this opportunity, and he's one person I met about 3-4 days ago. Actually, put it up last week, sometimes last week. And that is to say, really, this life is vanity. Sometimes we must really work very hard and, achieve what we are able to achieve within the time that we have, Mr. Speaker. Suleiman Dori also showed us quite a lot of things. In his funeral, Mr. Speaker, and as one colleague has mentioned, politics were not evident in his funeral. It was done very quickly, Mr. Speaker, something that I think sometimes we put a lot of effort in trying to pamper somebody who's passed. I think the best thing, Mr. Speaker, is to quickly, deal with the rights that are involved and let the family rest and the person who has died rest in peace. Mr. Speaker, as I wind up, Mr. Speaker, I really want to thank your office and that of, I want to thank you personally, Mr. Speaker, and the office of the clerk. Because members within that short duration, a few members were able to go to Mombasa and en route to Kwale, where they participated in his funeral rites. That was very kind of you, Mr. Speaker, and membership, thank you for that. I thank you.
Special request from a member from Kwale County, the Honorable Tandaza. Member for Matuga, yes.
Asante sana, Mheshimiwa Speaker, kwa kunipatia fursa hii, kwa kuwashukuru wabunge wenzangu ambao tuliweza kufika pale jana, wabunge wa nchi nzima, wa tabaka mbalimbali, wa dini mbalimbali, lakini wakaweza kufika Kwale Msambweni kwa kuweza kumsafirisha ndugu yetu Mheshimiwa marehemu Suleiman Dori. Ningetaka pia kutoa shukurani kwa wale ambao kama mlivyozungumza sisi Waislamu ukiwa umeaga ukifanya masaa matatu, basi huwa pia umechukua muda mrefu sana. Nafikiri hili ni jambo ambalo ndugu zangu wabunge walifahamu. Kwa mfano, ikiwa nitaaga saa 9, pengine kufikia saa 11 nitakuwa nishazikwa. Kwa hivyo ningewaambia tu wale wenzetu kwamba kwa sababu tunajua kwamba tuna Waislamu, wawe tayari kwamba wakati wowote mwenzao Muislamu akiwa ataaga, basi wawe wako tayari kusafiri. Lakini jana hili lilidhihirika kwa sababu tulikuwa na waheshimiwa kutoka kule magharibi, kutoka Mlima Kenya, kutoka juu Northeastern na maeneo yote yale. La mwisho pia ningetaka pia kuwakumbusha wenzangu kwamba kwa desturi yetu, matanga yetu sisi huwa tuzungumzi mambo ya siasa, huwa ni kuomboleza. Kwa hivyo ijapokuwa najua tumezoea, hata sisi tumeweza kushiriki mazishi sehemu mbalimbali za nchi ambayo siasa ndio huwa ni mahali pake, kule kwetu mambo kama hayo huwa hatuyazungumzii. Licha ya kuwa ikiwa ni kuzungumzia mambo ya siasa, tunajua kwamba sisi wa pwani, sidhani kama kukiwa na mashindano ya kupiga domo mnaweza kutushinda. Lakini wakati wa mazishi huwa tunanyamaza, tuendelee kuomboleza kwa sababu hiyo ndio desturi yetu. Ninawashukuru sana kwa msaada wenu, mchango wa kufika, mchango wa pia pesa ambazo mweza kutuletea, na kwa niaba yangu, familia na watu wa Kwale kwa jumla, tunawashukuru sana. Asante sana Mheshimiwa Speaker.
Now, the member for Kinango, is it? Yes, because because you already, unfortunately, I just confused the names, Tayari and Tandaza. You know, they are the same. They are the same. One is Tayari, the other one is Tandaza. So one is Tayari, the other one Tandaza. Yeah? Very well, Honorable Tayari.
Asante sana Mheshimiwa Speaker. Kusema kweli, kama wananchi wa Kwale na pwani kwa jumla, tumesikitishwa sana na kifo cha mwenda zake Mheshimiwa Suleiman Dori, ambaye alikuwa ni mpenda kufanya kazi, kupenda wenzake na kupenda nchi yake. Mheshimiwa Suleiman Dori, licha ya kuwa alikuwa mbunge wa Msambweni, mimi alikuwa rafiki yangu wa karibu sana, na tulizungumza mengi kuhusu maendeleo, kuhusu kazi yetu tunayofanya, na amesaidia sana wabunge wengi wa kutoka pwani kuwaonyesha jinsi ambavyo watajifundisha masuala haya ya bunge na kuweza kusaidia jamii kwa ujumla. Kusema kweli, nataka tu nishukuru sana wale viongozi wote walioweza kufika jana kwa mazishi, ijapokuwa muda ulikuwa ni kidogo. Familia wameshukuru sana kwa sababu mwanzo hatukutazamia kwamba tutapata idadi kubwa ya wabunge kuja kumsindikiza marehemu Suleiman Dori. Kwa niaba ya familia yangu na wananchi wote wa Kwale kwa jumla, nataka niambie familia pole. Mwenyezi Mungu awape subra na kheri katika wakati huu mgumu, na Mwenyezi Mungu ailaze roho ya marehemu Suleiman Dori mahali pema panapolala wema. Asante sana Mheshimiwa Speaker.
Well, honourable members, with so many of you, I know so many of you have something you want to say about our departed colleague, but it's just not possible. It's just not possible because none of you is going to agree to speak for 1 minute. So let those who have spoken suffice. Let those who have spoken suffice. It is not possible to have every one of us speak unless we want to set aside the business for today to eulogize our departed friend. But I believe those of you that have spoken sufficiently represent the majority of the House. Before we move to the next order, allow me to recognize the presence in the public gallery of students from the following institutions: Masai High School, Kajiado North Constituency, Kajiado County, and those from Manyata Boys High School, Kangundo Constituency, Machakos County. You're also welcome to observe the proceedings of the National Assembly. Next.
Order number 3, Messages. Order number 4, petitions.
The Honorable Tandaza Kasim again.
Thank you, Honorable Speaker. This is petition number 004 of 2020 regarding regularization of the Golini settlement scheme allotments. 1. I, the undersigned, on behalf of residents of Golini, Kwale County, draw the attention of this House to the following. 1. That residents of the then Golini location in present-day Matuga constituency have been living on their land for many years and utilizing it to sustain their economic needs. 2. That between 1969 and 1971, land in the said location was adjudicated for the purposes of registration, except parcel number with LR number 5003, which was registered as community land and occupied by residents as a community. 3. That in 1994, Golini settlement scheme was established on LR number 5003 with the intention to benefit the local community that owned the land under communal land tenure system. 4. That following the complaints raised by local residents, the District Plot Allocation Committee formed a task force in 2003 to look into the matter and recommend appropriate remedies. 5. That a ministerial directive made on 2nd March 2007 directed resurvey of the land in question, which process resulted in subdivision of 268 plots based on the recommendations of the Golini Settlement Scheme Task Force report. 6. That after the resurvey, Kwale County Lands Board and the National Land Commission sanctioned verification of the process with a view to hear and sort out any unresolved issues and recommend how to amend and or operationalize the task force report. 7. That since the 2007 resurvey, residents of Golini have never been issued with the fresh allotment letters, yet the initial map has not been abolished, leading to the erroneous allocation of the land. 8. That in 2007, the National Land Commission delivered its findings and recommendations at a public baraza in the presence of affected beneficiaries, noting that the said land was ancestral as evidenced by the homesteads, graveyards, and mature trees. 9. That residents have sought assistance from all relevant state institutions, but no satisfactory response has been given. 10. That the matter raised in this petition are not pending before any court of law, constitutional, or legal body. Therefore, your humble petitioners pray for the intervention of this House through the Departmental Committee on Lands to compel the concerned department to consider issuing them allotment letters in respect of the resurvey map of the year 2007 and restrain the beneficiaries of the allotment in the first survey from selling their respective plots before full issuance of allotment letters as per the resurvey of the year 2007 is concluded. And you petitioners will ever pray. Thank you, Honorable Speaker.
Very well. Honorable Tandaza Sawa. Tandaza Sawa. Na ule mwingine Tayari Stephen. Very well. The petition is referred to the Departmental Committee on Lands to prioritize and give a response. Next order.
Order number 5, papers.
Leader of the majority.
Mr. Speaker, I was consulting with the chair of transport because in their midst there was a man from the dynasty called Kositani. Honorable Speaker, I beg to lay the following papers on the table of the House today, Tuesday, March 10th, 2020. The reports and resolutions adopted at the second meeting of the third session of the 4th East African Legislative Assembly from the 16th of November to 7th of December 2019 in Arusha, Tanzania as follows. Reports adopted and tabled. The report of the Committee on General Purpose on the oversight activity to assess the level of preparedness of partner states in the management of the Ebola and dengue fever epidemics. Roman 2, the reports of the Committee on Legal Rules and Privilege on the oversight activity on compliance of the East Africa Community Protocol and the laws by the EAC institutions. Roman 3, report of the Second General Assembly for the East African Parliamentary Alliance for Food and Security and Nutrition, and 4, the report of the delegation of the East Africa Assembly to the 14th IPU Assembly held from the 10th to 17th October 2019 in Belgrade, Serbia. Resolutions adopted. Resolution number 1, resolution of the Assembly urging the Council Ministers to urgently establish an emergency response fund to assist victims of floods and other environmental disaster. 2, resolution of the Assembly requesting the Council of Ministers to produce a comprehensive report on the status of the implementation of the Custom Union and Common Market Protocols. And 3, resolutions of the Assembly paying tribute and congratulating the clerk, Mr. Kenneth Namboga Mandete, and Deputy Clerk Alex Lumumba upon the completion of their service to the Assembly. 2, the report and bills adopted at the third meeting of the third session of the 4th East African Legislative Assembly from the 9th to the 1st of March 2020 in Arusha, Tanzania as follows. A, the report of the Committee on Accounts on the East African Community audited accounts for the financial year 2017-2018, and 2, the report on the Committee on General Purpose on the East Africa Supplementary Appropriation Bill 2019. Bills, the East Africa Community Supplementary Appropriation Bill 2020. And lastly, Mr. Speaker, the 9th and 10th biannual reports on the status of alcohol and drug abuse control in Kenya. Thank you, Mr. Speaker.
Well, then I believe now the Committee for Regional Integration has more than a mouthful to handle. So I hope they are in the House, members of that committee. Next, the Chairman, Departmental Committee on Education and Research, Honorable Mele.
Honorable Speaker, thank you. Honorable Speaker, I also wish to pass my condolences to Honorable Dori, who passed on very untimely. So I send my condolences on my own behalf, my family and the people of Tindred for losing such a very good member of Parliament. Honorable Speaker, I beg to lay the following papers on the table of the House today, Tuesday, March 10th, 2020. Report of the Departmental Committee on Education and Research on the petition regarding the release of examination results for Mr. Nikki Odongo Lubanga by the Kenya Medical Laboratory Technologists and Technologists Board, and 2, the Colleges and Institutes Canada CICAN conference held in Niagara, Canada between 5th and 7th May 2019. I thank you, Mr. Speaker.
Next order.
Order number 6, notices of motion. Order number 7, questions and statements.
First question, nominated member Wilson Sosion.
Yeah, thank you, Honorable Speaker. I rise to ask question number 42 of 2020, directed to the Cabinet Secretary for Labor. 1, could the Cabinet Secretary explain why Safaricom Public Limited Company has been discouraging and inhibiting its employees from joining workers' unions of their choice, contrary to the provisions of Article 41 of the Constitution? 2, what action does the ministry intend to take against the said company for unlawful termination of employment of several of its workers due to sickness resulting from working for long hours in an unsafe environment at its call centers? I thank you, Honorable Speaker.
Question to be responded to before the Labor and Social Welfare Committee. Next question by the member for Nambale. The Honorable Sakwa Bunyasi.
Mr. Speaker, sir, I wish to ask question number 043 of 2020. Could the Cabinet Secretary explain how the national government intends to operationalize and implement Gazette Notice number 5853 issued on 21st June 2017, which established administrative coordination units, particularly in Nambale constituency? 2, what steps has the ministry put in place to ensure that there is adequate human resources and facilities in the said newly established units across the country, and in particular in Nambale constituency? Thank you, Mr. Speaker.
To be responded to before the Departmental Committee on Administration and National Security. Next question by the member for North Hall.
Thank you, Mr. Speaker. Mr. Speaker, I rise to ask question 044 of 2020, directed the Cabinet Secretary for Public Service, Youth and Gender Affairs. Roman 1, could the Cabinet Secretary provide a report on the implementation and operationalization status of the WEZO Fund program in all the constituencies of Marsabit County since inception of WEZO Fund in 2018? Roman 2, how much money has since been allocated and how much has been disbursed from the fund for the benefit of each of the 4 constituencies of Marsabit County? Roman 3, why are members of WEZO Fund committees in the said constituencies who were gazetted in 2019 are yet to undergo the mandatory induction program, and when is the exercise expected to take place with respect to the said members? I thank you, Mr. Speaker.
Similarly to be responded to before the Departmental Committee on Administration and National Security. Member for Gilgil.
Thank you, Mr. Speaker. I rise to ask question 45 of 2020 to the Cabinet Secretary for Interior and Coordination of National Government. The question is, what measures has the ministry put in place to ensure the implementation of the harmonized salaries program for the 1,774 graduate police officers in the country, in line with the declarations and orders given under petition number 122 of 2018 of 17th May 2019 by the Employment and Labor Relations Court sitting in Nairobi? Thank you, Mr. Speaker.
Again to be responded to before the Departmental Committee on Administration and National Security. That concludes questions. There are no requests for statements. So proceed to the next order.
Order number 8, procedural motion, reduction of publication period for a specified bill.
I'm informed that the majority whip is standing in for the chair of Budget and Appropriations Committee.
Thank you, Honorable Speaker. Honorable Speaker, on behalf of the Chairperson, Budget and Appropriation Committee, I would like to move procedural motion, reduction of publication period for a specified bill. I'd like to move that, notwithstanding the provisions of Standing Order number 120 and cognizant of the timelines contemplated under Article 218 of the Constitution and Section 42 of the Public Finance Management Act regarding the period for passage of a Division of Revenue Bill this House resolves to reduce the publication period of the Division of Revenue Bill, National Assembly Bill number 3 of 2020 from 7 days to 1 day. Honorable Speaker, this motion is self-explanatory that given the calendar of the House, Honorable Speaker, and given the timelines of this bill, of the bill regarding the division of revenue bill, Honorable Speaker, it will be only reasonable if we reduce the time for publication so that members can debate this as they end up going to recess. Honorable Speaker, there was very wide consultation as regards this bill. And I know even the IBEC were already consulted on this. Therefore, we don't see issues that would stop us from proceeding to reduce the time for publication from 7 to 1 day. Honorable Speaker, I wish to move, and as I move, I request members to understand that there is an aspect of conflict, especially when it comes to our calendar, and therefore we would want to reduce this publication period so that we can debate this and have our time to go on recess as we had earlier approved the calendar of this House. Therefore, Honorable Speaker, I wish to move and request now that the Chair of Budget has come to second this motion. Thank you, Honorable Speaker.
Thank you, Honorable Speaker. Let me thank Honorable Asheli for moving that motion on behalf. I was stuck in traffic. Honorable Speaker, I wish to second, and as Honorable Asheli has adequately articulated, considering that we are going on recess next week, at the end of next week, the short recess, we need to have published and at least table a report which we hope to be able to table by Tuesday or Wednesday morning, Honorable Speaker. And as per the constitutional requirements, Honorable Speaker, I think the Parliamentary Budget Office is already working on the advertisement together with the Clerk's Office for public participation. As you remember, it is now a constitutional requirement that even this bill, like all other bills, goes through public participation. Honorable Speaker, we are fortunate that this year, largely there has been concurrence on the figures that are to be shared between the two levels of government. But there are also challenges, Honorable Speaker, as I mentioned, as we concluded the debate on the budget policy statement on the issue to do with Nairobi County and the transfer of functions. And therefore, it is important that as much as the County Assembly in Nairobi is doing public participation on that issue, that we also give the greater public of the country an opportunity to make their representations on the question of division of revenue between the two levels of government, and even on issues pertaining to the transfer of functions between the two levels of government, between Nairobi County and the national government. And with that, Honorable Speaker, I wish to second.
Order members, order members, order members. Member for Alego, even if you are walking out, you don't just start stranding around. Order members, I propose the question, which is that notwithstanding the provision starting under 120 and cognizant of the timelines contemplated under Article 218 of the Constitution and Section 42 of the Public Finance Management Act regarding the period for passage of a Division of Revenue Bill, this House resolves to reduce the publication period of the Division of Revenue Bill, National Assembly Bill number 3 of 2020 from 7 days to 1 day. The desire of the House that I put the question. I proceed so to do. I put the question that notwithstanding the provisions of standing under 120 and cognizant of the timelines contemplated under Article 218 of the Constitution and Section 42 of the Public Finance Management Act regarding the period for passage of a Division of Revenue Bill, This House resolves to reduce the publication period of the Division of Revenue Bill, National Assembly Bill number 3 of 2020 from 7 days to 1 day. Will as many as that opinion say aye? Aye. Will as many as the contrary opinion say no? The ayes have it. Next order.
Order number 9, the Business Laws Amendment Bill, National Assembly Bill number 80 of 2019, second reading, question to be put.
Honourable members, I do observe that I note that there's too much noise at the front. Both the leader majority, his deputy, the deputy whip. I think there's something they are communicating across the bar with the leader of the minority party. And I'm sure they can do it in lower tones. Honourable members, debate on this bill was concluded last week on Thursday. What remained is for the question to be put, which I hereby do. That the Business Laws Amendment Bill, National Assembly Bill number 80 of 2019, be now read a second time. Will as many as that opinion say aye? Aye. Will as many as the contrary opinion say no? The ayes have it.
A bill for an act of parliament to make amendments to various statutes to facilitate the ease of doing business in Kenya and for connected purposes.
Next order, what? The next order is your business, Honorable Ishongwa.
Order number 10, the Division of Revenue Bill, National Assembly Bill number 3 of 2020, first reading. A bill for an act of parliament to provide for the equitable division of revenue raised nationally between the national and county government in 2020-2021 financial year and for connected purposes.
Honourable members, I just wish to, the member for Imenti Central, honourable members, I wish to alert the House before you go to the next order that you recall that last week I gave communication and guidance on how to deal with the President's reservation to the Law of Contract Amendment Bill, National Assembly Bill number 1 of 2019. So that, honourable members, as you recall, that bill has only one substantive clause. I think the first clause is about, I think, title or something like that. I don't think whether anybody has any issues with or any quarrel with the title. So, honourable members, as you know, at whatever stage, at every stage, don't run away. That's not, look at these ones now. That's the Honorable Kones or Honorable Cherule. Yeah, Honorable Cherule. You know now she opens the door and stares a bit and then takes off. Well, of course, I think she served in the other house, the last time, was it? I think she is used. So, honor members, as I did guide, when you go into the memorandum must be at every stage be supported and or opposed by not less than 2/3 of the membership of the House. So in the event that when you go into committee, you do not raise 2/3, essentially the bill will have been lost. And since they had only one clause, thereafter I will communicate the decision of the House to the Attorney General. So that because there's already a law, it was seeking to amend that particular law. So the law still exists with all the other provisions. So what will be left is for me to communicate to the Attorney General the decision of the House. But of course, should you have the 233 of you voting to defeat President's memorandum, then of course we will present the bill to the President as having been, with his veto having been overridden by not less than 233 of you. But obviously, in fairness, looking at the chamber, I think it will be a tall order. So, but the House is therefore accordingly guided that when you get to committee of the whole House, the member for Muhaya says that the House is going to mobilize yourselves into droves. Please go ahead. I have no hesitation, but that is for the information of the House. Next order.
Order number 11, Committee of the Whole House.
Order members, take your seats. Take your seats. This is going to be a very brief bill to be transacted. It's a memorandum, a presidential memorandum. And we do not have too much time. Kindly take your seats and concentrate so that you make your decisions.
President's recommendations to clause 2.
Order members, I propose a question which is that the President's recommendation to clause 2 be considered. And honorable members, I'm sure you've heard the communication from the Speaker. So I'll give an opportunity to the Leader of Majority, who is the mover, to move President's recommendation to clause 2.
Honorable Deputy Speaker and Chair, I propose that clause 2 of the bill be deleted as recommended by His Excellency the President and as it is appearing in the order paper. Mr. Speaker, whereas I could have wanted to witness this bill which I have moved on behalf of my friend Francis Waititu to see the light of the day, but after further reflection, which is informed by the reservation of His Excellency the President, within the reading of Article 115 of the Constitution, I wish to move that clause 2 be deleted. And the House should be aware that clause 2 is the substance of the bill. And I'm conscious that the deletion will have the effect of killing this bill in entirety. The justification given by the President, Mr. Chairman, is that the proposed amendment were reintroduced very prematurely. The provision contained in the bill were originally contained in the statute law. They were sphered from the bill in order to allow for more. Speaker, what is happening here? I mean, there are facilities provided for at the back of this chamber. Yes. And you know, if ODM wants to consult with Tanga on the most frivolous purported impeachment of the deputy president, which they cannot get it because they couldn't impeach Minister Kaimenyi. You know, if you can't impeach Kaimenyi or Honorable Waiguru, those who want to impeach the deputy president, you're wasting your time. You're wasting your time.
Order, Leader of Majority. Leader of Majority, you know, unfortunately, they were consulting somewhere down here. I couldn't be able to see them. Probably next time I'll ask you to mention their names so that I can see. But anyway, for today, let's leave it. Let's leave it. Let's leave it. What is your point? You know, what's your point of order?
I'm on a point of order. I'm on a point of order.
What is it, Leader of Minority?
Chair, you know, ordinarily I would not stand on a point of order to challenge the leader of majority, because, you know, we have to respect each other, which we have done. But when the leader of majority starts misleading this House and rewriting history, there is no time that ODM has initiated process of removal of Waiguru. It was done by Jubilee, and they ran away. They went to hide in hotel in Naivasha, Mr. Chairman. And even, Mr. Chairman, when we bring an impeachment motion, when that time comes, it will be a serious motion, not where you run to hide with mistresses in hotels, Mr. Speaker.
You have,
Mr. Speaker will be on the,
on the
floor of the House.
Okay, I hear you. The only thing, leader of minority, I am completely surprised that you are saying you ordinarily do not want to challenge the leader of majority. I thought that is actually your business, challenging each other. But I'm surprised that you are actually throwing in towels even before. So let's.
Chair.
No,
Chair, because I defended.
We don't.
I defended both Waiguru and Kaimenyi. I can't want to confirm to the House and go on record that Honorable Kaimenyi's impeachment was from a member of the Orange Democratic Movement, and Honorable Waiguru was from a member of Jubilee. But the signatures were both sides. And Honorable Speaker, from yesterday's burial of our brother, Honorable Bandi must read the signs of the times. The times. You know, yesterday I was in Kwale. But let me continue, Chair.
I don't think I'm going to allow you, Honorable Bandi, because
Chair, but I want to confirm. Chair, I want to go on record. The Chair, Honorable Bandi first must confirm and must tell the country why Tanga and ODM were having an informal meeting here. That's what the country wants to know. The chair of ODM and the de facto fake leader of Tanga.
What is your point of order, Honorable Ishungwa? What is your point of order?
So they must tell
Honorable
the country.
Ishungwa, what is your point of order?
Yeah.
What is your point of order, Honorable Ishungwa? And by the way, you know, I do not know that there are factions in this House. I only know members of the minority and majority. Other factions I am blind to. But what is it, Honorable Ishungwa? And why are you sweating at it is cool in this House?
Chair, I must confirm and confess that I am sweating. And I'm sweating, one, because I came in a rush, I was stuck in traffic, so I had to jog.
That was about
distance.
an hour ago, Honorable Ishungwa, so I mean, I do not know. Okay, if fever is persisting, then you probably need some attention.
The leader of majority is raising the temperatures in the chamber, talking about ODM and Tanga. And you know, I was consulting with the chair, ODM, and I was just consoling the chair because of the debacle yesterday in Kwale. And I had to console him because he's a member of my committee.
You know you are confusing.
And he was unable to read the signs of the times.
You are you are an alliance. Just a minute, I'm giving you. But you know you are an alliance alumni. And you know I wanted you to differentiate. You are saying you are consoling or consulting. Because you see, these are two different things.
Chair, let me take that again.
Yeah.
I was not consulting.
Yes.
I was consoling the Honorable John Buddy from the debacle yesterday in Kwale. And Honorable Speaker, John Buddy, not just being the leader of my minority, is also my friend. And hopefully the next governor of Homa Bay. And I will support him. However, the consultation was not between ODM and Tanga because we cannot be consulting here as political parties. When we consult with the leader, we consult as members of one committee in the Budget and Appropriations Committee. However, it is important.
What is your point of order?
That John Buddy,
you know, you are debating.
No, I was only saying, Honorable Speaker, that John Buddy must be able to read the signs of the times and also inform the leader of minority in the other house, Senator Orengo, that impeaching a deputy president who is elected by the people.
Okay,
and it starts here.
Now you
And
are,
they
you are
have no-
completely, no. Now let's stop it there. Let's stop it there. Honorable Mbadi, I don't think you have anything different. What is it again? And now that you are mentioned.
Mr. Chair, first you have allowed Honorable Chungwa to discuss a member of the other house, which our standing orders disallow. Mr. Speaker.
Actually, it's out of order on that one, but proceed.
Mr. Speaker, Honorable Chungwa could only console me for the loss of my member. But he cannot console me for what happened yesterday, because what I did was to respond to his boss, who also spoke in a funeral. I was looking for the immediate funeral to answer to his boss, who speaks carelessly in funerals. Mr. Speaker, someone is dead, you go to his funeral, and we are suspecting.
We are going a wrong direction.
And you go to his funeral.
Now let's proceed, the Honorable Leader of Majority. No. You have made your point. Let's now proceed. Let's deal with this very serious matter.
Mr. Speaker, Mr. Chairman, I think Article 150 of the Constitution is very clear, and people must, for the benefit of doubt, each one of you sitting here and out, read Article 150 of the Constitution in black and white, and you will understand where you are heading to. Don't drive to Thika Superhighway without brakes. Mr. Speaker, why the President negated this long-standing, Speaker, you know, Honorable Millie is a good friend of mine. I served with her since she was nominated in the 10th Parliament. So me and her, we know very well together that you cannot just, think of an action when you know the end result. It will lead to a crash.
Why don't we concentrate on this presidential memorandum?
So, yes. So this presidential memoranda, I just want to give the House the reasons the President gave. In that the proposed new provisions to Section 3 of the Law on Contract will negate the long-standing principle of contract, which are relied on by lenders, by borrowers, by guarantors, by investors, and other stakeholders in the Kenyan economy, especially in the capital markets. Mr. Speaker, the obvious effect will be to prolong the process of settling debts. If we remove guarantors, the process of settling debts in our country, in the case of a default, through a prolonged, asset tracing and litigation, without the assurance that the outcome will be positive. The current system, Mr. Chairman, is prompt and is very predictable in terms of debt settlement. So the President feels it's a key element in Kenya's ease of doing business. The law we have just passed, the Business Laws Amendment, is one of the laws that will help us in making sure Kenya becomes top in the world and in the country in the ease of doing business. So if this law passes, as what the President is saying, then we will make investors, we will make other players in the capital markets not to invest in our country because it will create a hindrance and it will affect the principal aspect. I beg to move and agree with the President.
So, honorable members, I propose the question, which is at clause 2, be deleted as recommended by His Excellency, the President. Now, let's hear their members. I see the leader of minority, and you know they have precedents as per our standing orders. I will give some members. Actually, I'll give about 6 members. So let's start with the leader of majority. No, I'll give 6 honorable members because some of these things they may not. Let's hear what they have to say.
Thank you, Mr. Speaker. Mr. Speaker, Mr. Chairman, this is really a sad afternoon, in my view, for this House, because really the presidential power to ascend and return bills was given to the President to exercise with a lot of caution. And Mr. Chairman, this amendment, the amendment that was proposed by Honorable Waititu, was a very good amendment. Because really, if someone borrows money and asks you to guarantee that money, and that person fails to pay, the procedure should be that all your property should be exhausted first, is when you go to the guarantor. So, but Mr. Speaker, Mr. Chairman, I know there is very little we can do because you require 233. But I want to say that I think the people of Kenya needs to look again at this provision in the Constitution giving the president too much powers, that we require 2/3 to override the recommendation of the president. Mr. Speaker, it gives the president absolute powers to legislate. In fact, the president can just bring a very weak bill, you make amendments, and then it goes to State House and redo the entire bill. And bring it back, you fail to raise the numbers, and that becomes the law. I don't think that is what the people of Kenya intended with this provision in the Constitution. I oppose, but there is little we can do, but I have to go on record that I'm opposing the president's recommendations.
Okay. Where is, I see the chairman, JLAC, Justice and Legal Affairs Committee.
Thank you, Mr. Speaker. Mr. Speaker, I stand to oppose the memoranda by the President. Mr. Speaker, the essence of this amendment is actually, it sought to provide that in case of default by the principal borrower, then the bank or the creditor, generally, Mr. Speaker, should first realize the assets of the borrower before you pursue the creditor and the grantor, Mr. Speaker. Mr. Speaker, Kenyans have suffered under this law. Mr. Speaker, because what has been happening is that banks, upon default by a borrower, don't bother to follow the borrower. They pursue the assets of the guarantor. Mr. Speaker, that is the position in our law today. And so this amendment really, Mr. Speaker, was to take care, to protect the interests of the guarantors. So that, Mr. Speaker, those borrowers who borrow and they have their assets, and they even sometimes, Mr. Speaker, conspire with the creditors, Mr. Speaker, to defeat the realization of their properties, Mr. Speaker. And therefore, Mr. Speaker, I stand to oppose, because this is to protect the long suffering of guarantors from SACCOs, from banks. And Mr. Speaker, but the way you're protecting these guarantors, Mr. Speaker, the malicious principal debtors who have able to pay their principal debts but collude with the creditors who then do not call for repayment from the principal debtor. Okay. Mr. Speaker, now, what is happening
you will have
in
to
this
summarize,
country,
Honorable Cheptumo, because you have given your reason.
I am finishing, Mr. Speaker.
Yeah,
we even went ahead, Mr. Speaker, to look for some other jurisdictions. In Australia, Mr. Speaker, before you pursue the principal borrower, you actually, before you pursue the creditor, Mr. Speaker, I mean the guarantor, you pursue the principal borrower. Mr. Speaker, that is the situation in Australia. And we want to say, Mr. Speaker, this law indeed was meant to protect the guarantors who actually genuinely guarantee loans for principal borrowers. Mr. Speaker, it is a justifiable amendment which we need to support. Unfortunately.
Okay, Honorable Milemba. And please let us be brief, if really other members must speak. Because
very briefly, thank you, Honorable Speaker and Chair. This is actually another sad moment, because the amendment brought to us was actually supposed to protect the large populace of Kenyans who are actually acting as guarantors. And it was not limiting in any way the space for business, because all it was doing was to make the principal borrower first his assets be exhausted before we go to the guarantors. Unfortunately, it has gone the way again of Article 115, which was given to the president in order possibly to oversight Parliament whenever it has its gloss and excesses. But unfortunately, those powers are now being used to actually make laws And like one speaker said, as I conclude, Chair, that this is a gap that Parliament must take care of, because now the President can make any law. It's a matter of creating a weak law. It goes to him, and he simply now rewrites a whole bill, brings back to Parliament, and we don't get the 2/3. We are actually surrendering the powers of Parliament. Thank you, Honorable Speaker. I beg to oppose.
Honorable Kimunya. Honorable Kimunya.
Mr. Speaker, Mr. Chairman, I've heard the comments from my colleagues, but on this, I have to agree with the President. When you go borrowing money, you borrow on the premise that you are prepared to pay, not to default. So we must, first of all, never pass laws here that will give a culture of almost encouraging people to default. And that's why you not only give us security, but you also give your guarantors who are jointly and severally enjoined in the process. And hence, you cannot then say, because the person has given a home, which is probably matrimonial, and which cannot be realized at the point of default, that the bank should continue pursuing that until they realize they should be able to go to the guarantors and should choose even which is the most realizable facility. And this is global practice. So, Mr. Speaker, I could see the sense in which, perhaps because of the frustration, because of what the reality on the ground, and the several pages that we are seeing in the newspapers of auctions, I could see the pain through which the Honourable Member brought this amendment. But we should look at the bigger picture, that Kenya cannot be seen as a country that is legislating to encourage people to default on their debts. And that is a fundamental principle. Otherwise, you become a pariah nation. Who will trust you? That soon you will not even then be legislating on other things that affect investment. A bank lending money to a person is using public funds. It's depositors' money that's being lent. It's not just the bank. It's John Buddy as a customer who deposits his money and is then lent out to his colleague, right? If his colleague fails to pay, it's John Buddy who will lose, the Honorable John Buddy, who will lose on a deposit. So let us not just look at the banks. Let us look at the banks as purely an intermediation forum where you're taking money from depositors and lending it to borrowers, and you must protect both the borrower as well as
I heard you, Millie, and don't repeat that.
Mr. Speaker, Mr. Chairman, I think I could go on and on, but because of, for obvious reasons, I think let us pass this
okay.
And hope as a House,
Honorable,
and as a House, let us be careful.
Okay.
Let us be careful in future as we legislate on these laws that we don't end up putting the House into this kind of situation.
Okay.
Thank you,
Honorable Kioni. And then I'll give one person, one member from this other side, and that will be it.
Mr. Chairman, I find difficulty supporting this proposal from the President, for the reason that I think it does exactly the opposite of what Mheshimiwa Kimunya was saying. If you know that once you have borrowed money, you either pay or your other assets have become exposed, you'll be encouraged to pay more. But when we know that you can always get your guarantor's asset, I think you encourage readiness from the bank. And I think while we cannot,
you know what Honorable Kimunya is asking is that why then don't you do create a law that deals away with guarantors?
Now he had the opportunity of doing that. The one we have is the one that was done. So I think he can do that later. But Mr. Chairman, I think having said that, I think the other important thing is the office of the President will have to be careful not to be seen to be overusing the veto power. Because if it's overdone, again, it will beat the purpose for which it was put in the Constitution. Mr. Speaker,
what is it, Leader of Majority? You are the one moving it.
No. Mr. Speaker, Honorable Kioni also joined Parliament at the same time with the Honorable Millie and Mbandi. The framers of the Constitution gave him powers from Article 93, 94, and 95, and to protect the citizens of this country from a future or current rogue parliament, the president has been given under Article 115 to exercise, to protect the people. So he cannot stand here. Is he in order to stand here? Is he in order to stand here to exercise his powers under the Constitution, but questions the powers of the president as a CEO and elected by the people of Kenya to protect, members of parliament like Honorable Kioni. And nobody, Mr. Speaker, Chair, nobody can force you to be a guarantor. A guarantor is a willing business. So if you become a guarantor, unless you are like Amos Kimunya, who his name is a guarantor. Amos Kimunya's name is a guarantor, my name is a guarantor. We don't look for guarantors. But if you are a guarantor and it's defaulted, now I'm saying, I've finished my point of order. I've said you cannot.
Now let's have Honorable Kioni.
You cannot succumb the powers of the president. That is his powers.
Honorable Kioni, and you wind up, please.
Mr. Chairman, I can't just wind up. He's taking all the oxygen in the room. Mr. Chairman, I was going to say this, that power that was given to the president is a good one, yes, but it's meant to balance. And we agree that he's a people's representative also, but all those who are seated here are also people's representatives. So when we pass law, we pass it on behalf of Kenyans. I know when he makes those interventions, he makes them in terms of on behalf of Kenyans, but some balance will be useful. And I think it is important that we do that. But Mr. Speaker, as I wind up, I think this would have actually helped the banks want to become, because now they are just lazy. You give money and you want to follow everybody who put his signature on that piece of paper, and without forcing the person who borrowed to pay. I think it was a good amendment, but unfortunately, we are cooked.
Okay. Honorable Wino. Honorable Wino.
Thank you, Chair. What this bill is going to do is to kill guarantors. And Chair, you remember there's no money circulating because the SMEs are not borrowing anymore. If you line up the borrower with the guarantor at the same time, nobody will guarantee anything. And that is why the economy is going down. So I oppose this, and I'm so sorry that the president could knock down such amendment. This was going to help us in long run.
Okay. Now, honorable members, I am putting the question. And I have to enlighten the Kenyans, not you. I know the members are well enlightened on this. Even if there will be a voice call and you make a decision that it is a nay, the ayes will still have it. Let me restate that one. Whatever the circumstances, the ayes will have it, and this is the reason. The reason is that we need to raise 2/3 if you have to overturn a presidential memorandum. And this one going forward, and you remember, honorable members, one chair who sat here some times ago and made such a decision, the Kenyans felt that it was a wrong decision. It was indeed right. When you are dealing with a matter that requires 2/3, the only option for a chair to do is to call aye, so that the membership can stand on their feet, 30 of them, you confirm that they have the required numbers. If there will be no numbers, it will fall on the face. We will not even need to proceed. I'm not saying this for I'm not saying this for the members. I know the members are aware, but I'm trying to remove and disabuse members of public from sometimes criticizing Parliament when we make decisions from this chair on that basis. The reason why we will do that is because we need to confirm the numbers. Even looking at the membership in the House, they may not be 2/3, but I'm not going to simply make that decision myself. It is for members to stand and then be counted. That is the position. So, honorable members, I put the question. Which is that clause 2 be deleted as recommended by His Excellency the President. Will as many as of that opinion say aye? Aye. Will as many as of a contrary opinion say nay? Nay. Yet the ayes still have it. Right? That is the position. So let's see the member standing. Yes. Now, you are now 25. You are now 25. In fact, 5 less than the required number to even ask us. Take your seats, honorable members. Take your seats. Take your seats, honorable members. You do not have numbers, and therefore, the presidential, you are 28 now. The presidential memorandum is passed. You do not have numbers. You do not have numbers. No, you do not have numbers. Next order. Next order. You do not have numbers. You do not have numbers, and therefore, let us move reporting on this. The move of the bill. Move of the bill.
Honorable Chairperson, we know we are not even 233. I beg to move that the committee to report to the House its consideration of the President's recommendation to the Law of Contract Amendment Bill, National Assembly Bill number 1 of 2019, and its approval thereof without amendments.
Very well. And therefore, I put the question, which is that the committee do report to the House its consideration of the presidential recommendation to Law of Contract Amendment Bill, National Assembly Bill number 1 of 2019, and its approval thereof without amendments. Will as many as of that opinion say aye? Many as of a contrary opinion say nay? The ayes have it.
Order, members. We are not done with the Committee of the Whole. We have one more piece of law that we have to deal with, and specifically the representation of special interest groups, Laws Amendment Bill, National Assembly Bill number 52 of 2019. What is your point of order, Honorable Miri?
Thank you, Chair. Chair, I'm very concerned that we are proceeding in this House as though there are no women members of Parliament. In the matter that has just been concluded, only male members of Parliament have been given opportunity. And Chair, I also want to raise a concern that when you are raising a bill as important as the one that you have just dealt with, where you need the numbers and yet we may not necessarily get those numbers, there's nowhere we are rushing. Every member's voice needs to be heard. I am here representing the people of Suba North, and they need to hear that I opposed a law that is oppressing them, Chair. So we should not, even though the executive may have their way through this super legislation, but you cannot then force us not to speak in this House.
Very well. Order. Honorable Junet, you can't have a point of order over over and above the other one. Honorable Miri Odhiambo. Order, Honorable Miri Odhiambo. There is no doubt that you are here to represent the people of Suba North. There is absolutely no doubt. And you must be given a chance to speak to that whenever there is an issue. And obviously, sometimes it's not possible for all members to speak on one, but your concerns are noted. Clause 3. Honorable members, I propose a question that clause 3 be part of the bill. There is an amendment by Honorable Kioni.
Yes, thank you, Mr. Chairman. I propose that clause 3 be amended as provided for in the order paper.
It is important for the sake of members to very clearly say the import of your amendment so that we carry along all the members.
You have to explain to us, my friend. Political parties? No, it's not just about political parties, Mr. Chairman. The amendment serves to introduce additional functions to the GEC, or the National Council of Persons with Disability. And these functions serve for the purpose of encouraging the participation of persons with disability. The purpose of this amendment is to widen the scope or the work that is supposed to be done by the Council of Persons with Disability, and that will make it easy for them to take part in the electoral process.
Very well. Honorable members, I propose a question that clause 3 be amended as proposed by Honorable Kioni. Seems like members don't. Honorable members, I therefore put the question that clause 3 be amended as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Honorable members, I now put the question that clause 3, as amended, be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Clause 4. Honorable members, I propose a question that clause 4 be part of the bill. There are no amendment to that. I now put the question that clause 4 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Clause 5. I propose a question that clause 5 be part of the bill. There is an amendment by Honorable Kioni.
Mr. Chairman, this is another amendment by the committee, and I propose that the clause 5 be amended as provided for in the order paper. And the purpose for this amendment, Mr. Chairman, it is that it is meant to ensure that the IEBC uses modes of communication that can be used by persons with disability, and also to ensure that IEBC has a criteria for classification of marginalized and ethnic communities. And this is just to help in getting one to know the exact number of people and their distribution, but two also to make sure that they have modes that can help them communicate and take part again in the electoral process.
Honorable members, let me propose a question, then I'll give 1 or 2 members, let me proceed. Honorable members, I propose a question that clause 5 be amended as proposed by Honorable Kioni. Honorable Miri.
Thank you, Chair. Chair, Honorable Kioni needs to explain himself there because I'm not very convinced. Because the original provision was targeting persons with disabilities. But when you talk about special interest groups in general, and you are talking about communication, then we are presuming that the issue of communication affects everybody equally. Yet persons with disability, with hearing disability and visual disabilities are the ones that require that kind of special attention. So can he clarify to us why he's moving away from the persons with disability?
Before, Honorable, can you just take some notes? I'll give you a minute. Honorable Sankok.
Thank you very much, Honorable Chair, and I really support what Honorable Kioni have brought as an amendment because, Honorable Chair, most of us go through a lot of difficulties in the voting process. Most of the buildings are not accessible where voting is taking place, and those on wheelchair may not be able to access. And again, the hearing impaired category and the visually impaired, that is the blind and the deaf, Honorable Speaker, find it very difficult when there is no voting papers in print. In fact, in Braille, they have to ask to a second party, whom sometimes may not belong to the same party or the same school of thought as you. You ask them, where is the name of Uhuru Kenyatta? They will tell you, tick here, because it is where. Thank you very much, Honorable Speaker. I do support.
Honorable Majority Leader.
I think following Honorable Millie, my reading of this section 5 is the chair is saying that IBC will be given in this law the powers to develop a criteria, either through a regulation, on how to identify marginalized and minorities. But the Honorable Sonkok is talking about on the voting day. You know, how to help people with disability. No, here is about here is about the criteria. Because, you know, tomorrow, like in where Honorable Millie comes from and Honorable Bandi, now they fall under this minority marginalized. But Kaluma cannot purport to be minority. Am I right? So there are big tribes and there are small minorities, like myself and Honorable Millie and Honorable Bandi. So all that he's doing is, he wants IPC to develop a criteria to say Suba is a minority within the reading of Nyanza ethnic bloc. That Honorable Duale's clan is a minority within that.
Very well.
That's what I think Honorable Kioni is saying.
Very well.
So that is
Honorable Kioni, we shall give you a stab just after Honorable Udo. Then the House will make progress.
Chair, thank you for this opportunity. I find these particular amendments very interesting. Interesting in the sense, one, the state of minority or marginalized ought not to be permanent unless it is physical disability. The issue of minority community is simple a question of inability to do things that increase the numbers in your community. We should surely look at it afresh. Thank you.
Order. Honorable Udo, what is it that you said that the entire House rose on point of order? Minority leader, what is this that looks extremely out of order from what Udo is saying?
Mr. Chairman, with all due
Honorable Udo, please have your seat.
With all due respect to my friend and very strong party member, Honorable Undo, Dr. Undo, he is imputing improper motive on minority communities in this country. Mr. Chairman, how can he imply that Subas are few because we cannot do what is expected of us to add to numbers? What is he implying? Is he implying that Suba men are less of men or women? So he should withdraw that, Mr. Chairman. He should withdraw and apologize to the minorities of this country.
You know, Honorable Udo is a professor. Honorable Udo is a professor. So, Honorable Udo, you are being educated a bit on how. No, honorable members, I want the House to make progress on this. What is out of order, Honorable Junet? We must make progress on this. Honorable Udo, what is Honorable Junet? What is out of order?
The last census that came out, disabled people like Songkok were 6.5 million people. For how long are they going to be minority? They are majority. They are equal to Kikuyus in Kenya. 6.5 million people suspect.
Honorable Songkok, order, Honorable Songkok. Honorable Songkok, order. You cannot respond to every question, every issue raised on the floor. Honorable Miri, we will make progress on this. Honorable Miri, then I will go back to Honorable Kioni. We make progress.
Thank you, Chair. Chair, even though I'm both a minority and a majority. Because my mother is a Luo, I am a majority. Because my father is a Suba, I'm a minority. So we might also provide a criteria for minor majorities. But that is not actually what I'm raising. Chair, I'd raised an issue for Honorable Kioni, but I'm noticing where the confusion is because he's talking about clause 5 in general, when he has two amendments, D and E. And Chair, I have no problem with E, which is providing criteria for including minorities and marginalized. And actually, I've just presented to BBI on the same issue, which I agree with. My concern, which I would need him to address, is in relation to 5D. And 5D, where he's removing persons with disabilities and replacing it with special interests. And yet it is an issue of communication. Is he not then marginalizing persons with disability?
Very well. Let's now give Honorable Kioni sufficient time. Honorable Kioni, you may have, I'm sure you have noted what the members are raising. Would you speak to those concerns so that you carry along the members, so that it is clear?
I think, Mr. Chairman, one of the things that we need to understand about this bill is that it is meant to make it easy for the persons with the special interest groups, for them to access elective positions. And when we look at Article 100, you cannot single out one category, like the persons with disability. So what this particular area we were trying to do is to open it so that you cover the five criteria. But still, even when you are dealing with persons, the minorities, they also need to be facilitated. You may come across a minority that requires special communication modes. They do not know languages. They cannot quite be able to vote as we vote easily when we get into a polling station. So these special groups, we need to make sure that IEBC, Mr. Speaker, I see Oudo is on his feet at the wrong place. I see another team of...
all the members, Honorable, just consult in lower tone so that you give Honorable Kioni sufficient time and space to explain himself. Honorable Kioni, please.
Yeah, so it is ideal to ensure that even the other categories are also covered by this provision that was before meant just for the persons with disability. And I don't think it is marginal.
All the members, we must proceed on this. I put the question that clause 5 be amended as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 5 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Clause 6. Honorable members, I propose a question that clause 6 be part of the bill. There is an amendment by Honorable Kioni.
Thank you, Mr. Chairman. I wish to propose that clause 6 be amended as provided for in the order paper. And again, this amendment is the same reasons that we had used for clause 5 applies for the clause 6, Mr. Speaker.
Honorable members, I propose a question that clause 6 be amended as proposed by Honorable Kioni. I now put the question that clause 6 be amended as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 6 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Clause 7. I propose a question that clause 7 be part of the bill. There are no amendment on that. I therefore put the question that clause 7 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Clause 8. I propose a question that clause 8 be part of the bill. We have an amendment by Honorable Kioni.
Thank you, Mr. Chairman. Again, I propose that clause 8 be amended as provided for on the order paper. And the purpose for this amendment, Mr. Chairman, is to hata ujui ni nini unasema kuna goja niseme.
Order, Honorable Kioni. Honorable Kioni, don't listen to anyone. Just move. The House will make a decision.
Yes, he makes a lot of noise, sharp noise. That is the problem. Mr. Speaker, Mr. Chairman, this is that we are actually the provision is that we are allowing those parties that don't have a website to be able to do it elsewhere, because some parties may not even have the resources to set up a website. And we have members here who are party. For example, we have some small parties like Chama cha Mapinduzi, DP and such. They don't have money that can help do them a website.
All the members, I propose a question that clause 8 be amended as proposed by Honorable Kioni. Yes, Honorable Majority Leader.
Mr. Chairman, the Honorable Chair, I don't think whether he wants to really help democracy to get its roots very well. He is taking back this country to the days of the briefcase parties. And we cannot legislate for the emergency of briefcase parties. If you cannot set up a website, it's about 50,000 shillings. If you can't set up a website, then you should not be called a political party. I oppose and ask the House to oppose it.
Yes, Honorable Junet.
Chair, I oppose that amendment. I know the chair, Honorable Kioni, is an expert in forming political parties, especially towards the election, Mr. Speaker. And I'm sure he's laying ground. He's laying ground to come up with another one. Mr. Chair, this one, we are not going to allow it. I remember UDF. Now he wants to start another EDF. I know. Mr. Chair, let him start first by having a website. Then from there he can have the political party. Chair.
Very well, very well. Honorable Bui, you wanted to speak to this?
Chair, much as I believe that democracy requires that we have more parties than one or two, I think on that issue of website, I think that's a bare minimum. Honestly, a party that can't even set up a website really shouldn't have any space in today's day and age. So I would like to oppose that particular one.
Yes. What is it, Honorable Kioni?
Mr. Chairman, one is that there is again another person here who thinks that I form parties. I form serious parties. Parties that contest elections and they field candidates. All the parties I have been to have presidential candidates. Yes. And we have done very well. We have done very well. And in one of them I was
get to the subject. Get to the subject matter.
And,
don't do to a lot of arbiter. Get to the subject, please.
In fact, other than for the fact that they stole our votes, we would have done much better. But I wanted to say this, that I have seen the issue and I hear the members, I want to withdraw that amendment.
Other members, that stands withdrawn. I therefore put the global question, that I now put the question that clause 8 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 9.
I propose a question that clause 9 be part of the bill. Honorable members, there are 3 amendments to this. There is an amendment by Honorable Jeremiah Kioni, Honorable Robert Bui, and Honorable Godfrey Osoti. So, if the Honorable Kioni, we shall give precedence to Honorable Kionis. If it is carried, then in effect, the others will fall. If it falls, we will have to proceed to Honorable Buis as well as proceed to Honorable Osoti. So, Honorable Kioni, you have the first tab.
We are killing all of them. This one we have to kill. That is
Mr. Speaker, Mr. Chairman, I propose that clause 9 be amended as provided for on the paper. And I ask members to just allow themselves to, exercise their mind on this issue, and 2, to quite understand even why we created this political parties fund in the Constitution. And Mr. Speaker, Mr. Chairman, there isn't much departure from what was provided for before. The only thing that we have done is that we have provided 73% of the money be shared among parties. And I want to talk to Mheshimiwa Junet. Having this 73% provided for as it is still does not take away what ODM is entitled or what Jubilee is entitled. No? Why are you saying no? I did not know that you are that difficult when people are moving amendments here. But I am getting... Because
Honorable Kioni, members are not difficult. They are just very keen on what you are saying.
Yeah, and I am saying that you will still be able to take your percentage because it will be based on the number of votes you get. So it doesn't take away anything that you are getting from this fund. What we have also done, what this does also, is allowing any other political party that has qualified to farm people in parliament to get some funding. We have, Mr. Chairman, we have political parties here with 18 members. We have political parties here with even 100 MCAs. But they cannot be able to get any funding from the national kitty. Why? Because we only said that you can only benefit from this money if you get the 5% total or 3% of the total vote, which is a good thing. And I know the big boys here will be very happy to continue with this one. But it doesn't grow our space. It does not grow the political space. It does not grow democratic space. And for the persons with special interests, marginalized, minorities, youth, and the others, listen to this. Listen to this. If we don't have more parties out there where persons with special interest groups can take part in, we will never be able to bring them on board. But if we allow parties to field them out there, including women, then that way we get them. But this is only possible if you fund these political parties. We have political parties here, Mr. Chairman, that immediately after an election, they die. Why? Because an individual cannot be able to sustain a political party from his pocket. And this constitutional kit was meant to benefit our democratic space, Mr. Speaker. Mr. Chairman, I'm asking that we support this amendment. And I want to tell you that you may think that you are strong today. Wait until you are hit out there, and you need to be able to get support out there. You need these parties elsewhere, and I am asking you, Majority Leader, you know these positions don't exist forever. Please provide for that you may need to use tomorrow. And the person who is wise in making law is that who makes law for his enemy.
Very well, honorable members, there seems to be quite a bit of very active passion around what Honorable Kioni is saying. To open a bit of debate, I will propose a question that clause 9 be amended as proposed by Honorable Kioni. Yes, let's start with the majority leader. I would like to give to a few other members, especially those that haven't spoken to this. Yeah. Let's start with
Mr. Speaker, Mr. Chairman, I thought Honorable Kioni was in the 10th Parliament when we enacted this Political Parties Act that created the fund. And the essence of this fund, the objective, was even to kill briefcase parties owned by individuals. Today, I want to confirm that if you go to the headquarters of ODM and headquarters of Jubilee, is similar, and I've been to, is similar like going to the headquarters of the Conservative Party and the Labour Party in London. I have been there. Chair, what he's proposing, let me give a scenario. There is a possibility that a president can have less MPs and less governors and less senators, because maybe all his candidates were getting number 2, but he has no members of parliament here. It happened in the 10th Parliament. Kibaki was a president. I was in ODM. He had only 48 MPs. PNU had only 48. ODM had 106. And let me go on record. And there was no, coalition is different. Even today, why Honorable Mbui is bringing the amendment, he's in a coalition. But the money belongs to ODM. The money on our side belongs to Jubilee. Whether you have got 5 MPs, whether you have 5 MPs, you have 6 MPs, you are a squatter. You are a squatter. You can only get money on our mercy. On our mercy. And Mr. Chairman, we must go the US way and the other developed democracies. This country will be more stable. This country will be more stable. Parties will have discipline if we have 2 major parties. The problem with this amendment, is you are telling us that somebody who has come to this house with the 2 MPs, 3 MPs, to share resources with the Jubilee who has 170, with the ODM who have about close to 100, taxpayers' money. Mr. Chairman, the die is cast. You are supposed to work hard. ODM worked hard. They sold their ideology. Jubilee sold their ideology. If the people of Kenya refused you the 5% margin in the law, I urge this House, we reject this amendment. And secondly, the chair is trying to amend the Political Parties Act through the back door. So we should even reject clause 9 of the bill. After we reject the amendment, Please let us, and Chair, you take us slowly. We want to reject even what is in the clause. For you to be a political party recognized in law, you must have the 5% required. Honorable Mbui, Honorable Otsotsi, Honorable Kioni, go and campaign. Talk to the people of Kenya. If they decide to give you 10 MPs, like Kanu, and they gave ODM close to 100, and they gave Jubilee 170, it is the people of Kenya, it's not us. You cannot amend. Please join our parties.
Very well.
The small parties.
Very well.
Oppose
Very well.
the one in the...
I'll give to a few more members. I'll just expand a bit. And please, members, I'll be a bit restricted because this is not second reading. So you don't want to be very extrapolated in terms of debate. Allow this. You speak to the amendment specifically because it's not the second reading. I will, after Honorable Badi, I will give to a few members, particularly even those that have an amendment to this. Honorable Badi. Yes, we'll give a few members.
Mr. Chairman, you know, when you decide to mix portion with food, it can't be eaten. So the chairman had some very good amendments touching on issues of engendering our political parties. But he decides to mix it with what I would call a poison. But it's now creating an avenue which we sealed and closed in the 10th Parliament, that we don't want these briefcase political parties that consume taxpayers' money, and yet they are individually owned political parties, like the one of Kalembe Ndile. Now, Mr. Chairman, I want to urge the House that these amendments on Clause 9 are irrelevant. We reject all of them, and even go ahead and reject Clause 9, so that we go back to where we are in terms of political party funding. If anyone wants, Mr. Chairman, if a member wants to amend Political Parties Act, let that member bring a standalone amendment, and we deal with it. Mr. Speaker, I oppose.
Very well. Before I come to my right, let me give Honorable Sotsi, who actually has an amendment to this. No, he is speaking to Honorable Kioni's amendment, not his.
Chair, I have an amendment, but when we get there, I'll be withdrawing my amendment after consultation.
We'll come there, Honorable Sotsi.
But allow me to comment. Madam Chair, Mr. Chair, you know,
It is Mr. Chair, not Madam Chair.
The basis of my amendment was basically to try and correct a technical...
No, don't speak to your amendment, Honorable Sotsi. Speak to Honorable Kionis. We shall give you a chance to speak to yours when time comes.
Yes, looking at Honorable Kioni's amendment, you know the bill was talking about 53% share. But it seems they have increased that share to 73%. I want to agree this is a very fundamental change. And in fact, in the first place, when I read this bill, I wondered why we were attempting to amend substantially the Political Parties Fund, the Political Parties Act, the section that talks about the Political Parties Fund. Because essentially this bill is about Article 100. So if you want to bring in issues of sharing of the fund in the Political Parties Fund, I think that was hugely fundamental. And I want to agree that it is important for us to relook at the Political Parties Act, but not through this one.
Very well.
So I am opposing this amendment.
You are opposing. Yes, we'll come to Honorable, the other members, we shall give them, but let me go to my right, Honorable Kimunya. I'll still come back this way. It looks like this clause has quite a bit of interest. Yes. That's why I'm lingering a bit.
Yes, Mr. Chairman, I am actually opposed to this amendment, partly because of the ambiguity contained within. If you look at all the clauses, first of all, section 25(1) is talking about the distribution. When you look at 2, the conditions for a party to receive money, right, are even worse than you know, it's like the party has to have 2/3 in terms of office bearers. which is the same to that rule that we have been unable to legislate in this parliament. The party has party nomination list. You know, there's a lot of things there that party has at least a governor, 5 elected members of parliament, 12 elected members of county assemblies. Now, you're creating a hurdle that a party could actually win the presidential, miss this, and then it cannot even participate in the political parties fund. So I think I would urge that perhaps Member Kioni, this may have been well-meaning, but the drafting has changed it all much, yeah? And perhaps it may need to be withdrawn and then redrafted afresh and as an amendment to the Political Parties Act. I'm also very concerned that we are using one act to amend another act instead of amending the main act itself. And I think there's been rulings on that, yet we are not doing. It's not a miscellaneous amendment bill, right? This is a standalone bill. But we are now using it to amend other bills, other acts, right? Instead of going to those, especially on matters political. And we need to be very careful. When we are touching on the Political Parties Act, let us come here with proper amendments to the Political Parties Act so you can look at it in its totality rather than through the issue of special interest groups, and then we end up now amending the funding of the political parties.
We have like two, 3 members, then we make progress. Yeah, you get a chance. But yes, Honorable Bui, I know you are moving also an amendment, but I'll give you a chance to speak to Honorable Kioni. Let's have Honorable Junet first.
Chair, this issue is very serious. Chair, if you look, I oppose first this amendment, but Mr. Chair, 73% of the fund proportionally shared among the political parties subject to Section 2. Chair, what this means, if a party, they are saying must have 1 governor, 12 MCAs and 5 MPs. Can you imagine, Chair, a party calling itself a political party with 12 MCAs out of 1,450 MCAs in the country? Then you want to call that a serious political party that needs to be funded by the taxpayers' money, with 5 members of parliament here, out of a parliament of 416 members, Chair. You are telling me a political party that has 5 members should be given taxpayers' money to run its affairs. Chair, this is, I beseech the Chair to withdraw. We don't need to vote on this. Chair, we must have serious political parties in this country, like ODM. Okay. In fact, this afternoon, I came to this House, Chair, basically to shoot down this one, Mr. Speaker, because this is an affront to democracy. How can you have a party like UDF, where the chairman used to belong, which has died a long time ago? So if they were funded by taxpayers by now, they're down here. Chair, secondly, you see the sequence of things. He has started first by saying a party must not have a website. Then he said they must be funded. Chair, don't joke here with our intelligence. Get rid of this thing and withdraw it, Chair.
Very well. Let's hear Honorable Bui. Honorable Bui has an amendment to this clause. Let's hear him. But not on you as Honorable Bui, but Honorable Kioni's amendment.
Yeah, thank you, Chair, for the opportunity. You know, Chair, as I speak first, I want to declare that I'm a member of Wiper Democratic Party, not a briefcase party. Wiper is the 3rd largest party in Kenya. And Mr. Speaker, we came into Parliament through a coalition arrangement. And there was a hope that all parties would get some money, and therefore would get some share out of the money for that. But anyway, Chair, on the issue of
Honorable Bui, Majority Leader is on a point of order. I'll come to you. What is out of order, Honorable Majority Leader?
Mr. Speaker, Chair, what is out of order is Wiper is not the 3rd largest. Wiper is at the periphery of complying with the 5%. When you talk about the 3rd largest, you are misleading the House. When you talk about 3rd largest, you must be closer to ODM, around 90. But you are just 1 MP to be declared not compliant with the 5%. So don't say the word 3rd largest is wrong. Just say you are at the bottom and you have survived to comply.
Honorable Bui is from that Wiper party. And Honorable Bui, the Majority Leader seems to have an issue with the 3rd largest.
I will tell you this, Chair. It's a simple English statement. The #1 party is Jubilee. #2 party is ODM. Number 3 party in Kenya is the Wiper Democratic Movement. And Mr. Speaker, we are also a parliamentary party because we have a member of the Parliamentary Service Commission. We have a commissioner. Because of our threshold, we have achieved the threshold. It is in law. Anyway, so Chair, now let me go to my issue. My issue is this. On the issue of the funds, and why I support Honorable Kioni's amendment is because the proposal that was there before, Chair, was that 53% of the monies would be shared amongst the top 2 parties. And then 20% would be shared amongst all the other parties. So in essence, what that was showing me is that Wiper would be thrown to the bottom with all the other briefcase parties. So that's why I said it's only fair that we put all the money and share it proportionally, which means that if a party has 80%, they get 80%. If a party has 1%, they get 1%. Why would you be worried if you already have the lion's share? I support this amendment of the chair.
Why don't we make progress on this, honorable members, really? But anyway, Honorable Onyango hasn't spoken. Honorable Onyango hasn't spoken.
Thank you very much, Mr. Chair. Mr. Chair, I want to oppose my proposal by my friend, Honorable Kioni. At a time when BBI is trying to bring inclusivity, he's trying to dismember parties so that a small briefcase party that's going to have 3-4 can also benefit. People are going to school so that they can live better lives. Why are you degenerating, trying to pull us backward? In good faith, Mr. Kioni, whether it's personal and you have already sensed defeat in your party, but you still would want to benefit, Kenyans are not going to allow you because it's a time when people are crying of the public exchequer being overloaded. We cannot allow briefcase parties to go and dismember our exchequer.
Very well, honorable members.
I oppose.
We must make progress on this one, honorable members. I now put the question that clause 9 be amended as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The nays have it. Honorable members, honorable members, in that, honorable, what is out of order, Honorable Tiende? Yes, just be on. Just be on mic. Yes, Honorable Tiende.
Chairman, I'm saying I've been on a point of order. I pressed the intervention button, and I did not want to outshout. I wanted to use the rules. So, Mr. Chairman, you should look at the rule, this gadget, because I did have a point of order, although that motion is now carried, but there was a point we needed to have. I will try and bring it out later.
Honorable Tiende, that is noted, but surprisingly, on my screen here, actually it doesn't show that you're on a point of order. I should have given you. But not noted, order members, order members, yes, what is it, Honorable Miri?
Thanks, Chair. Chair, maybe you need to guide us so that we are on the same page. My understanding since we started this electronic process is that when you're in the committee of the whole house, when you want to contribute, you actually use the intervention button. So if Honorable Otiende has put the intervention button, it will appear that he wants to contribute, that is not in a point of order. So I think we have gone back, when we are here, we go back to the old system, where unfortunately you must outshine, what do you call it? Not outshine, but outshout others. So maybe if you can be clear on that, so next time he cannot sit waiting, like the good lawyer he is. Some of us have learned bad practice here of shouting.
Very well. What I was saying for purposes of Honorable Otiende is that whether he pressed on the point of order to speak or to raise a point of order, his actual name does not appear on that intervention from my screen, but probably my people need to check on that. Honorable members, now having dispensed with Honorable Kionis, the way the House has, Honorable Bui will have a stab, has an amendment to clause 9, and therefore, Honorable Bui, you have the floor. Honorable Bui.
Mr. Speaker, I wish to say that mine does not have all those issues that have been raised by Honorable Kioni. Mine is a very simple one. No. Mine is a very simple one, but Chair, considering the mood of the House, I feel that this will be an exercise in futility. So I feel that I stand no chance against the members. Because, Mr. Speaker, ideally, mine was just to try and combine the monies that were proposed in the law. Instead of sharing them out, two parties on their own and the rest of the parties together, I just said put it all together and let parties share proportionately. I think that was really the import of my proposal. And then also, Mr. Speaker, I also said in this that, of course, the issue of
Honorable Bui, it is important. You know, I want to be clear as the chair. Are you moving or withdrawing? You know, at some point, I heard you withdraw. At some point, I see like you are prosecuting your case.
You know,
where are we?
You see, Chair, you know, there is no need to just withdraw without mentioning the import of why I had proposed this. So that is what I was doing.
Yes.
I was just indicating, the import. Why is withdrawing? The import of
you see, you're putting on Honorable Bui too much pressure.
No, there's no pressure.
Honorable Bui, but if you are withdrawing,
I'm very clear
then you want to save the time if you are withdrawing in that case.
Have you withdrawn? Yes, I think under the pressure that is in this house, the condition I've seen, I think I will just withdraw that amendment and hope that we can probably make amendments to the actual act itself, so that we can create some fairness in the sharing of the monies.
Very well, honorable members, that is marked as withdrawn, the amendment by Honorable Bui. We have a third amendment by Honorable Sotsi, still on the same clause. Honorable Sotsi, you have the floor.
Mr. Chair, as I had said earlier, after consulting my coalition leadership here, I withdraw my amendment. But just to say a few things, I had put in this amendment to correct the technical issues in the bill in terms of apportionment, because they were talking about National Assembly only.
Very well.
And yet we have the Senate.
Very well.
And also the fact that we depend on the number of votes garnered.
Very well.
In the preceding election.
And
then lastly, Mr. Chair, I have also noticed that the political parties which were supposed to benefit from this amendment are not even represented here.
Very
they are
well.
not here. So I withdraw my amendment.
Very well. In that case, honorable members, the three amendments, I will now put the global, honorable members, order. I will now put the global question, because all amendments under that clause have fallen. And so, honorable members, I'll put the question that clause 9 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The nays have it.
Clause 10.
Honorable members, I propose a question that clause 10 be part of the bill. We have an amendment by Honorable Osoti. Honorable Osoti, you have an amendment to clause 10, don't you? Honorable Osoti, you have an amendment to clause 10, don't you? You have the floor.
Mr. Chair, I have amendment clause 10, and the gist of this amendment is that the bill is proposing that the special interest groups, that is including the youth, women, persons with disability, marginalized communities, shall...
Move the amendment and you explain yourself.
Shall benefit from funding.
Order for record, just move the amendment, then you explain the import and the reason.
Mr. Chair, I move the amendment. The bill is amended as per the order paper. And the gist of this amendment, Mr. Chair, is that this particular clause proposes that the person's special interest group will benefit from civic education, capacity building, facilitating party candidates in the campaign, publicity, and such other measures as may be approved by the registrar. My amendment is to ensure that persons who have already benefited in the way of representing in parliament or county assemblies shall not again come later and demand to benefit from all these provisions listed here. For example, Mr. Speaker, if I'm a woman rep of some county and I've served 5 years, I should not come after 5 years to say, again, I want to benefit from capacity building, civil education, facilitating party candidate campaign. I think that would be unfair. And that applies also to the youth who are in parliament or county assemblies. So that once you benefit, somehow you do not benefit the second time. So that is the gist of my amendment on clause 10.
Very well, honorable members. I propose a question that clause 10 be amended as proposed by Honorable Tsotsi. There seems to be no much interest to speak to that. Yes, Honorable Udo.
Honorable Chair, I'm constrained to oppose this amendment for simple reason. One, for simple reason. Number two, for one, once you have given the political party the funds, it is again too much of cumbersome and onerous to go and dictate to them on how to use that money. Secondly, assuming that a second timer has no need for support, again contradicts the whole essence of the amendment. I do believe that while the amendment might have some merit, but the way it is framed is completely wrong, and I stand to oppose. Thank you.
Yes, Honorable Majority Leader.
Chair, you know my history in this house, and Honorable Millie is the one who really understands. You need to look at every amendment. This amendment is one basically saying if you are a member of parliament, you cannot be nominated. Forget about the other stories. You know, the amendment seeks to ensure that the measures to be adopted in terms of new paragraph A shall only benefit a first-time candidate who is seeking election for the first time either in parliament or county assemblies. This will therefore ensure the person benefiting from the fund within the political party shall be entitled. This, we must refuse it. And that's why I really want to ask Honorable Bande and the rest. The devil is in the details. So we must reject it. I oppose.
Very well. Very well. I had mentioned Honorable Member for Madari. I'll come to, I see the Minority Leader want to speak to this as well. Honorable Member for Madari.
Thank you, Chair. I am constrained to oppose this amendment for the very simple reason the principle under which Honorable Kimunya shot down or proposed that we shoot down the other amendment would apply here. I am a member of the committee and I was persuaded that our clause was good until the point was made, and a very important point, that you cannot amend another substantive act through an act that you're introducing. For that reason, and however meritorious the point that Honorable Osotsi is bringing, it ought to come through the parent act, which is a political parties act. For that reason, I oppose.
Honorable Minority Leader.
In addition to what Honorable Anthony Luoch has said regarding these amendments to various statutes, which I don't think are necessary, I also want to add, Mr. Speaker, the beginning of the amendment, from the beginning it said that to promote representation of the marginalized groups, the parties are supposed to provide funding for civic education, capacity building, facilitating party candidates in campaigns, publicity, and such other measures. That makes sense and is good. And that is, by the way, even the law now requires that at least 30% of the funding to political parties should be used in this marginalized group. But look, Mr. Speaker, down B under B, and more particularly 2, that a person shall benefit from the provisions of this paragraph where the person is seeking to be elected for his or her first term in parliament. Mr. Speaker, why do you stop if a party decides to fund a particular candidate in, say, Soba? The party feels that the candidate in Soba require support so that he or she can win that seat. But because that candidate is not contesting for the first time, the party will not give the funding. I mean, what kind of legislation is that? So it doesn't make sense, Mr. Chairman. And that's why I'm saying making amendments to an act of parliament using other acts sometimes becomes very untidy.
Very well. Let's have two other members speak. Honorable Rono hasn't spoken on this. Do you Honorable Kioni, what are you saying? You get a chance, certainly.
Yeah, but you are not doing it the right way.
Honorable Kioni, you seek a chance to speak, you'll be given a chance to speak. Honorable Rono, do you want to speak to this? You have registered interest.
Chair, I had proposals on the previous one. That's why my thing kept flipping. Otherwise, I was unhappy with the selfishness that it was shut down. But I stand guided.
Okay, very well. Before I come to my left, so that then we conclude. Honorable Kioni.
Mr. Chairman, I think as the chair of the committee, it's only fair that even when members have a different view, to allow us to say why it is that we think even the views they have are not correct, so that it goes on record. But if you look like you are bullying us from where you are, it is not.
Order, Honorable Kioni, you have the floor. Please speak to this.
Yeah.
You definitely have the floor.
I will tell you, Mr. Speaker, and I want to speak to the previous one. This amendment by Ososi, even if we had another one as a committee, is maybe he wasn't able to place it properly. But the intention was to ensure that as many persons with special interests are helped to come to campaigning, to learn how to do things. But when you start saying that one person is the only person who needs to be helped 2, 3, 4 times, then you are not widening the space for these persons with special interest. So the wording maybe captured this wrong. We had it at a 9, which has been shot down. But the intention of that amendment was not to stop a person from running. Once you have been facilitated by the party and you have come to parliament, then you should now be able to, you have learned the ropes. Go and do it. Let us facilitate another one with special interest so that you can see whether he can also come to parliament. What are we trying to do eventually? Is increase the population of persons with special interest in parliament without appointing them, without pouring them through the back door. And I think, Mr. Speaker, it is important that we know that it is just a matter of time. We are in big parties. But how many of the big parties are able to bring persons with disability? How many of the big parties are able to bring women? How many of the big parties are able to bring the minorities? If we were able to widen the scope, we will have more of them in parliament. But if we don't want them in parliament, then the essence of these amendments will not make sense. And I think that is very important for us to get it on record. Because I know when we now come to campaigning, you will hear people saying that they want persons with this and the rest. So, Mr. Speaker, I wanted to mention that. But I see there is a problem with the wording of Ososis. But the intention, you speak 90% of the time in parliament, Mutu akizungumza hapa, you are still speaking.
Just proceed.
I just wanted to clarify that. And I have no problem. Once the bill has been shut down by Parliament, see Mimi, see Ninyinyi.
Yes. Why don't we make progress on this, the House, to really rule on this? Honorable, last Honorable Dual. Then the House will make a decision.
Thank you, Chair. Chair, I'm constrained as well to oppose this. And Chair, I do this because I have sat here and I'm concerned by the understanding and meaning we are giving of special interests, marginalized. And Chair, it is my considered opinion that we are misleading not only the House, but a number of people. I stand here, Chair, nominated. There's a sense in which one would think that that is a special interest. But I think when we start making law, including what this amendment seeks to be doing, that is micro, in a way, managing what political parties should do programmatically. And when we approach the political parties as if political parties are not by themselves constitutionally and in the way that they are organized, expected to recognize the different categories of persons who are participating, Chair, it becomes a very big challenge. And my major reason, therefore, for opposing this is that it doesn't really, to me, seem to make sense that you are beginning to tell political parties that there is going to be marginalization or that there will be a need to support only at a particular time. I think, Mr. Chair, what we need to understand is that there are structural and there are situational and there are different contexts that political parties need by themselves to be aware of. And these can range. It could be age, it could be disability, it could be just the minority, it could be geographical location. So, Chair, I oppose this, and I encourage that as we talk, Chair, we need to have a lot more sense and a lot more agreement in what we are calling special interests, what we are calling marginalized. Political parties that have a small number are not marginalized. They just need to work on their ideology. Political parties do not, Chair, need to be given money so that they talk about the ideology. They just need to define it and sell it. And they can sell it to women, to men, to persons with disability, and to others. Chair, I oppose the amendment.
Honorable members, I now put the question that clause 10 be amended as proposed by Honorable Osotsi. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? No. The nays have it. Honorable Osotsi did not even vote on this one. Other members, I now put the global question. I now put the question that clause 10 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 11.
I propose a question that clause 11 be part of the bill. There are no amendments to that. I now put the question that clause 11 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 12.
I propose a question that clause 12 be part of the bill. We have an amendment by Honorable Jeremiah Kioni.
Mr. Chairman, there is a typo thing, and I propose that clause 12 be amended as per the order paper.
Well, just put the import again, Honorable Jeremiah Kioni, so that the members understand.
It's written sections, and we are saying section. Just typo, removing the S because it's one section that we are dealing with.
Very well. Honorable members, I propose a question that clause 12 be amended as proposed by Honorable Kioni. I now put the question that clause 12 be amended as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 12 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 13.
Honorable members, I propose a question that clause 13 be part of the bill. Honorable Jeremiah Kioni, you have an amendment?
Yes, that we are delete clause 13. Because we are, we thought that this is very close to micromanaging the parties.
Honorable members, I now put the question that clause 13, I propose a question. Honorable members, I propose a question that clause 13 be deleted as proposed by Honorable Kioni. Yes, Honorable Majority Leader.
Now this one, the chair has seen the light of the day. You know, this fund belongs to political parties. There is no fund for special groups. There's no fund for nominated MPs. The fund is supposed to be a kitty for political parties. Then political parties will find a way of doing civic education within their parties to entice special groups and their interests. So I'm happy you are not micromanaging political parties. You have deleted. I support it.
Honorable Miri.
Thank you, Chair. Chair, actually, I wish to oppose this one. Chair, if you notice, even when we moved the clause 9, as Honorable Mbadi had actually said, he brought poison with medicine, so it made it very difficult, because then it provided for especially representation of women and ensuring that you have more women, through the parties. But you know, as we increasingly see these amendments going, anything that has to do with special interests, which covers also women, we are very quick to dismiss. And yet parties have no clear formula of doing this. And I can tell you, Chair, I've been elected now twice. And there is no formula in my own party of supporting me as a woman, and with all the challenges we face. So for me, even though I know I'll be a minority on that one, I don't support the deletion.
Honorable members, why don't we put the question on this? Honorable members, I now put the question that clause 13 be deleted as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? Nay. The ayes have it.
Clause 14.
I propose a question that clause 14 be part of the bill. Honorable members, there are no amendment to that. I therefore put the question that clause 14 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clauses 15 and 16.
I propose a question that clauses 15 and 16 be part of the bill. There are no amendments on the two clauses. I therefore put the question that clauses 15 and 16 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 17.
I propose a question that clause 17 be part of the bill. Honorable Jeremiah Kioni, you have an amendment to clause 17?
Yes, Mr. Speaker, it is to bring on board the special interest groups. I propose that clause 17 be amended as per the order paper.
Honorable members, I propose a question that clause 17 be amended as proposed by Honorable Kioni. I put the question that clause 17 be amended as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 17 as amended be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 18.
I propose a question that clause 18 be part of the bill. Honorable Kioni, we have two amendments by Honorable Kioni and Honorable Otsotsi. We'll start with Honorable Kioni's.
Mr. Speaker, Mr. Chairman, I propose that clause 18 be amended as contained on the order paper. And this is requiring the political parties to submit a party list. Yes. Now I get it. Mr. Speaker, Mr. Chairman, the purpose of this amendment is to try and make sure that we deny, and I want to use this so that Buddy can respond quickly. We deny just the two people to decide on who benefits from this nominations and such, so that you have a board that has minutes. You are able to consult widely. Yeah. So now we are moving it from Junet where only one person decides. So if you want to decide as an individual, you oppose this. But if you want the whole party to be involved in nominating persons, so that you don't bring in your girlfriends here and such things, then you can deal with that.
Honorable members, I will propose a question that clause 18 be amended as proposed by Honorable Jeremiah Kioni. Honorable Majority Leader, Honorable Minority Leader.
Chair, you know, there's nothing first if you propose your girlfriend. She's a Kenyan. And there must be a reason. But let me oppose it on one ground. Yes. What the Honorable Junet is saying is unparliamentary, so I won't use it. Yes, I can be thrown out. But Chair, what Honorable Kioni is trying to do, I don't know whether he wants to join this group called special interest. He's creating special places for them. Now he's saying the party list, already IEBC does this. 45 days to the election. IEBC publicize, it's in the act. And every party has leadership hierarchy. And whatever nomination they do, they're based on regional, gender, and ethnic religion. So this is micromanaging political parties. I oppose, and we should not put, these are things administratively which are found within the political party's constitution. We cannot put what is in our party's constitutions and our manifestos and what we believe in into a law. I oppose, and let the House oppose that.
Let's start with, yes, we'll give, but let's have a minority leader first, please.
Mr. Chairman, Mr. Chairman, Leader of Majority. I wish Leader of Majority and the Chairman could give me time now. Mr. Chairman, first I wanted to say that at times, those of us who have experience in managing political parties, we understand some of these things better. And Mr. Chairman, I want to say that let us not over-supervise political parties. Each political party has its constitution of how to do nomination and prepare party list and submit to the IBC. If it does not follow the provisions of the constitution of that party, then definitely the IBC would not accept it. Let us also understand that political parties, Mr. Chairman, a political party is a club. You join it when you want, you leave when you want. If you feel that a political party is not treating you well, Mr. Chairman, you have the liberty and the option to leave. But finally, Mr. Chairman, the reason why I oppose this amendment, Mr. Chairman, let us not be obsessed with this idea of boards, committees. Mr. Chairman, I have gone all through this. In fact, ODM has a team, a committee we set in place to do the nomination and prepare it and give it to us. But not the party list, to prepare the party list. The problems we encountered was not from the one man you are talking about, from some of the membership of the people you give that responsibility. So it is as good as the people you put. It is as good as the leadership of that party. I would tell you, parties mature. And as we speak, ODM has reached a point that now our nomination, even if you were to fault, even the members we have nominated to this house, you will agree with me that we did justice to the membership of the party. We brought people who can represent the interests of the party and the interests of the special interest group. We have Honorable Sosion here, we have Honorable Professor Jacqueline Oduor, we have Honorable Danita Gatti. We have people who are actually representing the various special interest groups. So let's not look at parties like we are criminals. We are not. Political party officials are not criminals. We are responsible Kenyans. Thank you, Mrs.
I'll give you to Honorable Jeanette, but not before Honorable Tongi speaks. Honorable Tongi, please.
Thank you, Mr. Chairman, for the opportunity also. I've listened keenly on what my seniors have spoken. I've said about the amendment. But, Mr. Speaker, you want to, and the majority of the members would agree with me, that the list that has been given in the name of people who are supposed to be nominated, not in all cases that has worked to the interest of the country. Mr. Speaker, I know of some cases where we have nominated people or we have given proposals of people who should be nominated, and we end up with a different list altogether at the time of nomination. So I would wish, even if we don't amend the way Honorable Kioni was proposing, we get a list which is firmed up in law, sent to the, to the IPC, so that members who have already been proposed in the order of merit, Mr. Speaker, will be given that opportunity and not to be shortchanged at the hour of need, which has been the case in the past. Otherwise, that way we kill the parties. That's why we have created opportunities for the small parties to come up and take up the gap which has been created by these big parties who have always given priority to big communities and at the disadvantage of the small community. So that list should be, the list of nominated members or proposed nominated members should be publicized, and the order under which it is given should be followed by the law of Kenya, and if it's not, then we should be given an opportunity to go to court and challenge that list. I support the amendment with that proposal in mind.
Honorable Junet.
Chairman, in the interest of time, the issue is very clear. We don't need to micromanage political parties, Chair, on how they nominate their people. Every nominee you are seeing here, every person who has been nominated to this as Chair, has a role he has played in his political party, including a girlfriend. Everybody has a role to play in a political party. So, Chair, don't be bothered about that. Let political parties do their nominations in the... And by the way, the Chair in his amendment is proposing that we use election boards. All political parties have election boards. They are the ones who do the nominations. In the end, the one person that you are fearing is the same person who decides after even the board has done their work. So don't waste your time with amendments here. That one person will decide all the time, I can guarantee you. Thank you so much.
Honorable
Thank you, Chair. Chair, I'll oppose this for a principle, which I'm actually seeing running throughout this, and I'm actually seeing in other legislations. We are actually creating legislative confusion. Because what we are doing, when we are legislating on one place, we look at all the other acts everywhere and want to legislate them in that particular act we are amending. In the end, if you look at it, Mr. Chair, what will happen is that if you were to go this way, when the party is, when the political parties starts receiving, he will have to have about 4 laws. Did they follow their own laws as a political party? What about the Special Interest Laws Act? Was it there? What about the Political Parties Act? Then it will just be confusion. So I think we should limit them so that when you're amending one law, stick to that. If you want to amend others, go and amend them substantially. I oppose this.
Honorable Cheptumo.
Thank you, Chair. Chair, I stand to oppose this amendment. The mischief that Honorable Kioni is trying to address is the fear that the process of nominating members is abused. But Chair, if you see what we did recently in the law, before 2017 elections, the names of those people to be nominated were actually given after elections. But that mischief was addressed when now political parties are supposed to forward their names before the elections. And I think that is part of the way we've been able to deal with the mischief that Honorable Kioni is trying to do. Secondly, Chair, I want to agree with the sentiments by members. Whether you have an election board, whether you have a committee to look at these issues, ultimately, the leadership of that party will actually take the day in terms of determining who should be nominated. Members nominated, Mr. Chair, has certain roles they have played in political parties. Either they have been assisting the party in terms of campaigning and so on. I don't think this business of girlfriends, boyfriends, and so on is a major issue. What is important for us is to ensure that we allow political parties to deal with their issues, those are internal matters. And I think the way we are going now, political parties are becoming serious in ensuring that those nominated, Mr. Chair, are able to serve the interests of the party. So I think this mischief has already been addressed, and I oppose.
Honorable members, why don't we make progress on this? Quite a number of members have spoken to this. Let's then just get 1 minute so that we make progress on this. Quite a number of members have spoken to this. Let's start that way, Honorable Miri, just 1 minute, then we make progress. Quite a number have spoken to this.
Chair, I actually understand what Honorable Jeremiah Kioni is trying to do. It's just that maybe the way that he's phrased it does not deal with the issue. And Chair, the reason I'm saying that is that even if you look at the way, you know, in the last parliament, we formed a panel of members of parliament, especially for nominating MCS. One member in our county nominated everyone. And yet we sat and actually came up with a list, which is in law, as was provided in our party constitution. So when a person violates like that, what is the option that is available? And they serve their term. This term, something similar almost happened. And I know one constituency, I think it's Honorable Bara, or either Obaras or Lilian Gogos. I came up with absolutely no one. Again, because people were meddling. So I know that he actually has a very valid reason, but perhaps it's the way that he's put it that is not right. Because we need to find that, how to deal with the situations where individuals want to, hog the whole list, bring their sisters, brothers, not girlfriends, sisters, brothers, aunties, and stuff.
Very well. Honorable Baya hasn't spoken. 1 minute, please, so that we make progress on this.
Yes, I would like to support the amendment, and actually I want to ride on what Honorable Millie has said. The problem is not even at the National Assembly. The National Assembly here, we have quality nominations being done, and I think the process is okay. But at the county assemblies, that is where the problem is. I know, like she's given a Kilifi, the people that were nominated to Kilifi by ODM party, which is my party, which I respect, came from other places which were not Kilifi. Now, I hear you. What I'm saying is we need to regulate, and I think the most important thing here that this amendment addresses, the spirit in which Jeremiah Kioni brings this amendment is good. So, Mr. Speaker,
what is out of order, Honorable Majority Leader?
Mr. Speaker, we cannot solve parties' internal disputes on the floor of the House. We are dealing with the legislation. If you are shortchanged in Kilifi, that's your problem. I talked to the amendment on the party list. If the people were brought for them, then you were sleeping. Because the people from Garissa, nominated by Jubilee, were people who were consulted by the leadership of Jubilee.
Honorable Baya, what he's doing is to prosecute his case through a longer route. So,
I want to stand with Jeremiah Kioni that this is a valid amendment and we should support it so that we can kill cartels within parties. Thank you.
Very well, honorable members. We must make progress really on this. Honorable members, I now put the question that clause 18 be amended as proposed by Honorable Kioni. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The nays have it. Now, with that decision by the House on Honorable Kioni's amendment, we have Honorable Sotsi amendment, still on clause 18. Honorable Sotsi.
Mr. Chair, I want to move the amendment as indicated in the order paper. The gist of this amendment is basically to try and sort out the challenge noted in clause 18. Clause 18, Mr. Chair, says that there will be a statutory declaration signed by the person authorized to certify that the candidates were nominated by the party and the minutes of approval of the list by the party election board. Now, that particular part and the minutes of approval of the list of the party election board, that is what I'm seeking to amend because parties have a constitution. So the process of nomination is clearly specified in the party constitution. Secondly, Mr. Chair, before the nomination process, the IEBC, which is mandated by law under the Election Act, usually issues regulations which guide the process. So my amendment is to bring to light the issue that that process should be done according to the prescribed regulation and the party constitution. So that now that helps us in dealing with the issues that the members have raised on amendment by Honorable Kioni.
Very well. Honorable members, I propose a question that clause 18 be amended as proposed by Honorable Osotsi. Yes, Honorable Tom, member for Madare.
Honorable Chair, I'm going to support this for this very same reason I was going to support the amendments made by the Chair, the spirit of which was to safeguard the mischief of persons changing nomination lists which have already been decided on. So I think what Honorable Osotsi has done is to navigate away from the members concerned about being micromanaging political parties and saying, therefore, that we do this in accordance with the Constitution, and in that Constitution and the regulation, there will be the prescribed form, which is what the chair was trying to bring, and the authorized person. Because a lot of the times you find, and I've practiced a lot in political parties disputes tribunal, a lot of the complaints there is usually persons not authorized, sending a list to countermand the ones already sent, and another person sending a list to change the other person. So if we go by that amendment, we will have accommodated political parties without constraining them or micromanaging them and taking care of the mischief which Honorable Kioni and the committee where I sit was trying to deal with. Therefore, I support Mheshimiwa Osoti as amendment.
Yes, Majority Leader.
Chair, this amendment seeks to ensure that political parties are left to make their own determination for themselves on how they should conduct their meetings and reach their decisions in relation to submission of party list. Chair, this is an administrative, is found in the party's constitution. You cannot just legislate that. This is an administrative matter. Secondly, even this is found in the Political Parties Act, number 11 of 2011. And that's why I'll raise it again, I'll raise it in the House business tonight. Our legal team must always look at the relevant existing acts before they approve an amendment for a member. You know, Honorable Tsotsi amendment, we don't want a situation where, and I want to pick him as an example, where a nominated member of parliament is nominated by a party, and then midterm, he goes against the interest of that party, and that party cannot remove him. I mean, well, that's why we want party discipline. So this amendment, in my opinion, and I really want to ask Honorable Tsotsi, these are matters that you'll find in ODM constitution. These are matters you'll find in the Jubilee Party constitution. And I really want you, let us not over-legislate what Mbadi said. Please, I really beg you to withdraw it because it's not in the interest. You know what you're trying to do is you're trying to tell us we must provide minutes. Those are already there. Even you know how the leader of majority is, no, he's doing that. Basically, he's doing that. If you read Honorable Millie, I have taken, if you listen to me, I have taken a lot of time in scrutinizing all his amendments. Let me read for you. Clause 18 of the bill be amended in paragraph B by deleting the words and the minutes of the approval of the list by the party election board appearing in the proposed new subsection 2 and substitute therefore with the words in accordance with the prescribed regulations and the relevant constitution of the party. Now, no, you are talking about initially about minutes of the party, and you are referring it to the constitution of the party. What are you actually doing? You are legislating on a party matter, things which are found in the constitution. In my reading, this is about a party internal matters. There are minutes, their constitution. We should not bring it to a law on special interests.
Very well.
Yeah.
Very well. Very well. Honorable Udo, Honorable Tsotsi, we will give you the final stab, being your amendment.
Chair, thank you. It is a bit, again, confusing. We have literally dropped all the amendments proposed by the chair of the committee has been lost in respect of that particular clause. Again, bringing this amendment is, taking us to uncharted territory. My Honorable Sosi, my very good friend, but I want him to appreciate that the registrar of political parties, EIBC, would already be seized with the constitution of that party, the decision-making process of that party. We are literally overburdening the legislative framework or process in respect of this matter. Personally, I come from a county where we suffered so much. We got wrong people, flower girls, people who did not even support the party, but we swallowed it and accepted and moved on. We are hoping by the next time we are going for nominations or preparing the party list, we'll get the right people who support the party. Purely on a matter of principle, I ask for forgiveness because I have to oppose, but I stand to oppose this particular amendment.
Very well. Yes, Honorable Miri.
Thank you, Chair. Chair, I'd want members to listen to me keenly. If you actually look to what Honorable Tsotsi is doing, he is actually deleting, if you look at the proposed amendments in clause 18, which says Section 35 of the Election Act 2011 is amended by A, renumbering the existing provision as subsection 1, and B, inserting the following new subsection immediately after subsection 1. And the subsection 2, which it's talking about, says the party list shall be submitted together with a statutory declaration signed by the person authorized to certify that the candidates were nominated by the party and minutes of the approval of the list by the party selection board. So what he's basically doing is saying instead of micromanaging the party and telling the party to bring minutes, then scale it up and say use the party constitution or regulations. But if we are to go by what Honorable Duale is saying, then we need to reject Honorable Tsotsi's and reject the main one. But if we don't reject the main one, then what Honorable Tsotsi is doing is actually enriching this one. Based on the psyche and argument that has been espoused in this house, we are basically saying we don't want to micromanage parties. But if you tell a party to bring minutes of its board, election board, how much micromanagement than telling them to follow their constitution? I think telling somebody to follow their constitution is less of a micromanagement than telling them to bring minutes. So if we are not dropping this main one, then I think Osotsi's amendment is valid.
Very well. Yes, Honorable Kioni.
Thank you, Mr. Chair. I think this amendment is, it actually improves the quality of what you are doing, and I would want to support it and ask that members support it. This, we may be seen to be over-legislating, and I want to say that there was an aspect of that when we are making this bill. This has been one of the very difficult bills to come with, and we consulted widely. And I hear members, but I can tell you that this will come to haunt you later. But I think I want to support that amendment because of the many reasons, including what Mheshimiwa Miri has said. It helps to, why don't you want to do it as per your constitution?
Very well, very well. Why don't we'll give Honorable Tsotsi the final stab on this? Yes, Honorable, what is out of order?
Chair, reading at the amendments that was dropped or was lost, it read, the one proposed by the committee, read that clause 18 of the bill be amended by deleting paragraph B and substituting therefore by the new paragraph. So essentially, what have we done? We have deleted, the amendment calling for the deletion has been lost. By having voted to reject the B that had been proposed by Mheshimiwa Kioni in respect of clause 18. That's where we are, I suppose so.
So what is the issue, Honorable Tsotsi? Honorable Oudo?
So the issue is, what are we doing? If normally the procedure is, if the first amendment is lost, can you proceed to do the next amendment if it's already lost?
You know, Honorable Oudo, I appreciate your quagmire, but look, Honorable Kioni's amendment fell. It therefore means what is in the bill remains. And that is why Honorable Tsotsi got back to that, the status quo. What is now in the bill is what Honorable Tsotsi is dealing with. So it is in concurrence. It's going on well. If the Honorable Kioni one passed, it would have been a different matter. So Honorable Tsotsi, why don't you have the final stab on this?
Chair, actually, Honorable Mili has brought it out very precisely about the gist of my amendment. But what I would want to add on is that I think this amendment of mine, what it does, it removes that micromanagement of political parties and ensures that parties follow their constitution. Because the constitution of parties differ. There are some constitutions that talk about an election board. Others rely on the National Executive Committee to make a decision on the issue of nomination. Others can even go further and even seek ratification of the National Governing Council. So we cannot restrict political parties to the National Election Board alone. Knowing very well, National Election Board is a very junior body in the structure of political parties.
Your point is made. Honorable members, I will put the question that clause 18 be amended as proposed by Honorable Otsotsi. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I will now put the question that clause 18 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 19.
I propose a question that clause 19 be part of the bill. There are no amendment. I now put the question that clause 19 be part of the bill. Will as many as are of that opinion say aye? All the members. All the members. It cannot be that this afternoon has been this heavy. I'll take that again. You must vote. Either way. Honorable members, I now put the question that clause 19 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 20.
I propose a question that clause 20 be part of the bill. Honorable Jeremiah Kioni, you are proposing a deletion of that clause.
Do I now need to say it, now that you have said it?
Order,
Mr. Speaker, I propose that clause 20 be amended by deleting the said clause.
Just say what is more critical now for the members is to say the import of why you are deleting.
Again, I think I think this one we have covered it elsewhere, and we thought it was a repetition of what we have already provided for. And another thing, if that is not the case, procure and FAD. No, it is the issue of, again, the same issue of micromanaging. We are saying FAD access of special interest groups, and we knew this will have a problem with members. Telling them to FAD access for the special interest groups, the parties will have a problem. So I propose we delete.
Honorable members, I propose a question that clause 20 be deleted as proposed by Honorable Kioni. Yes, Honorable Miri.
Chair, I stand to oppose. Chair, if you listen to the language that has been consistent here is when you are talking about special interest groups, then we talk about micromanagement. Yet if you look at the Constitution, it says that the government shall take measures to ensure representation of women, persons with disability, including the taking of affirmative action steps. And in taking affirmative action steps, even by parties, does not really amount to micromanagement. And therefore, I would want to urge Honorable Kioni that it can't be too much to expect parties to put in a little funds to promote women, to promote persons with disabilities, to promote minorities within their parties. If that was not the case, Chair, look at this House. How many women have come in single constituencies? How many people have come in who are persons with disability? And that is our reality, and we must deal with it. That as of now, the representation of special interest groups is still very low and very poor, and we need to take measures. And these are such measures. And this is only media coverage. Even the parties can decide that our media coverage is on the website you are talking about. That is media.
Honorable Oruoch.
Mr. Chair, during the second reading when members were debating, I believe this is where the matter came up, the categories of persons called special interest, they cover all manner, they cover the youth, the women, person with disabilities, marginalized. And the concern here is the members here will actually be legislating to give advantage to their competitors, access to the media. And then to what extent, how much people will be taken to court by persons in that category that you need to pay for me to be on primetime news on KTN or on Citizen. The reasons were very valid, and the records on the Hansard clearly indicate members are very conscious that they will be placing an uneven ground during election for their competitors. It is for that reasons that we proposed its deletion. I support the amendments by the chair.
What is out of order in this house?
Chair, even though I don't want to interrupt my very good young brother, Honorable Anthony Alwach, but you see, in order to mislead the House, that giving an undue advantage where it guards special interest is discriminatory, because the Constitution actually encourages positive discrimination. It is constitutional. So you see, in order to mislead the House, when positive discrimination is constitutional. The Constitution allows my party to discriminate against you.
Very well. Honorable Watch seems to have agreed with you to that extent. What is the intervention, Honorable Kioni? Okay, very well. I guess we move fast now. Yes, Honorable Osotsi, 1 minute, Honorable Udo, 1 minute. Then the House will make a decision.
Chair, I support this amendment because this particular clause is repetitive. It seems to be repeating clause 10. You remember clause 10 talked about promoting the representation in parliament and in the county assemblies of special interest group through civic education, capacity building, facilitating party candidate in campaign, publicity. No, media coverage is part of publicity.
Very well.
Yeah, so I think it's repetitive. It has already been covered under clause 10.
Very well. Honorable Udo.
I also support the deletion. Honorable Speaker, as Honorable Loch has said, electioneering process begins at the party candidate expressing interest. It will be discriminatory, and secondly, it's already repetitive. And I want to urge Honorable Millie Odhiambo to accept we delete. In any case, and I wish all the special interest members in this House had the same passion like she has to sit these long hours, and yet we have so many of them who are nowhere to be seen. Thank you, Honorable Speaker.
Honorable members, I will now put the question that clause 20 be deleted as proposed by Honorable Kioni. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question, well, that clause is actually deleted now. We don't have the global question to that.
Clause 21.
Honorable members, I propose a question that clause 21 be part of the bill. Honorable Kioni, you have an amendment to that.
Yes, Mr. Chairman, I propose that we amend section 21, or clause 21, as provided for in the bill, or in the order paper, and we are just deleting the word flee. We don't want to say that parties should have should provide free access to parties. Again, almost for the same reasons that we have adduced for the other clause.
Honorable members, I propose a question that clause 21 be amended as proposed by Honorable Kioni. I will put the question that clause 21 be amended as proposed by Honorable Kioni. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 21 be, as amended, be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses, clause 22, 23, and 24.
I propose a question that clauses 22, 23, and 24 be part of the bill. There are no amendments to those three clauses. I therefore put the question that clauses 22, 23, and 24 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
New clause 16A.
Honorable Kioni, please move the second reading of that new clause.
Mr.
New
Chairman,
clause 16A.
I propose that we have clause 16A, new clause 16A, and the purpose for this
be read for the second time.
Thank you, Mr. Chairman. I propose that new clause 16A be led a second time.
It's good to say the import with the new clause members.
The import of this is to bring into the definition section the definition of special interest groups as provided for at Article 100 of the Constitution, which includes women, persons with disability, youth, ethnic and other minorities, and marginalized communities. And Mr. Chairman, as I say this, it's important to say that why a couple of these provisions that we had in the bill had difficulties is because, one, we had the same kind of debate in the meetings, but two, those who are supposed to benefit from these provisions are the ones who left, and the ones who are kept here are the ones who have continued hogging for everything, and they have continued, again, they have done the same thing. So while we still have some gains through this act, Mr. Chairman, we would have made much better progress if the marginalized, the minorities, persons with disability had remained in the House. And what Millie was saying to us, the ed, is actually the spirit of this thing. Some of the areas we look like we are overdoing it. But if we don't do some of these things, the groups that we are trying to cater for will still continue being discriminated and again kept out of electoral process. I hope one time we'll be able to allow ourselves not to become too academic and too very, when you want to take away from the others, you really make a lot of what I've seen on the floor. But again, I agree, it is the House that has done that, those deletions, but I thought I put that on record, that if the persons covered under Article 100 were in this House, they will have understood what we were trying to do, and we will be able, I don't believe, and you have been able to understand more. And if they had also paid attention to what the bill was about, I think there is a lot of trying to registrate because you have found the bill on the floor. That is a very dangerous thing.
Well, honorable members, I propose a question that new clause 16A be now read a second time. We have two members, then we make progress. Very well, very well. Let's then start there, the members who have interest to speak to this. Honorable Miri.
Thank you, Chair. Chair, I wish to support and agree with Honorable Jeremiah Kioni that if you are serious as a country in ensuring that we have special interest groups represented, then we need to clarify who they are, but not only clarify who they are, but also put measures in place, which would include monetary provision. And it is actually sad that we have dropped a lot of the provisions that are monetary in nature. The only thing is I wish that he had actually provided a category that we don't think about, which is the intersex category. A lot of people don't understand what intersex is, but usually many of them are actually people who are born with the two genders organs, and they don't know who they are, and they are mistreated. And for purposes even of parties, they don't know if they were to vie where they belong. So it would have been good if we included. And finally, Chair, I want to say that I'm happy to say that I belong to all these categories. I am a woman. In some countries, I heard that they were saying women with no children are persons with disability. then, Chair, I am a youth at heart. I belong to an ethnic and other minority of the Suba. We are also marginalized in Suba. So who am I to complain if we are represented in all those categories? I'm just not an intersex, though.
I don't know which country that is, where those without children are considered as people with disabilities. But that's interesting. Honorable Watch.
Yeah, I support this for the simple reason that Article 100 outlines who the special interest groups are. It would be neat for purposes of proper legislation that all the laws that we have are aligned to those specific ones, up to where this one ends, not the other ones that are been alluded to by Honorable Millie. And because Article 100 was one of those legislations that we had not, one of those for which we had not provided legislation, the Elections Act and all the other acts that have not been inconsistent in terms of the wordings of those categories, it is proper and in order, Chair, that we clearly define and delineate who are these special interest groups. I therefore support.
Honorable Udo, then Honorable Ososi,
Chair, I support the amendment in view that it complies with Article 10 or 100 of the Constitution of Kenya. But I'm left wondering, one, I'm not so sure whether women, being the majority in this country, still constitute special. Perhaps they're special interest in the sense that the domineering interest group, in that case, would then allow it to go. Secondly, on the issue of ethnic and other minorities, Honorable Chair, I say I will keep on stating and I have no apologies to make. It's a matter of choice because the process of increasing your number is very well known and documented. Finally, as I speak, I once again want to reiterate, and I want to sympathize with Honorable Kioni.
Whom do you want to inform?
Sympathize with
Honorable Miri, order. Honorable Miri, whom do you want to inform? The speaker? Or the one speaking? Honorable Udo, do you want that piece of information? It looks like may be helpful.
Chair, with due respect, I request that my senior colleague, in Parliament, shouldn't inform me, let me prosecute my case and complete. She'll have a chance to contribute.
Honorable Miri, you can give the information of a cup of tea, maybe.
Precisely.
Honorable Udo.
I was just concluding,
so that we...
as I was concluding, I sympathize with the Honorable Kioni, the chair of the committee. He is struggling to legislate for an uninterested group of people. We have 349 members of parliament. We have a large number of them who purport to be youth.
Yes.
We have a large number of them who are women. And yet, Honorable Chair, if you look around, you can only just see a droplet of those special groups. We are really, I hope we are not wasting legislative time. We are truly doing something. And I hope there will be a bit of interest.
Very well. Honorable Sossi, and speak to the amendment specifically so that we...
Chair, I want to support that amendment because what that amendment is basically doing is putting clarity to the Election Act as to the definition of special interest group. But Chair, if I may take you back, if you look at clause 10, which we have already handled, and I know we are not going back there because of procedure, we had said that these groups, the 5 categories of people, will benefit from civic education, capacity building, facilitation during campaigns, publicity, and any other such measures that may be approved by the House. You see now what we have basically done is that what we are saying that people, for instance, who are in this House, people like Ole Sonkok and others who are in this group, they will still go back to their parties for funding to do all these things. And that is why my amendment, a proviso, was to say that if you have benefited by
Don't take us back there, Honorable Sossi.
So I'm not taking you back, but I'm just informing the House that probably we will, at some point we may need to relook at this provision under clause 10.
Very well.
Because it is going to be discriminatory, and yet this bill is supposed to remove that discrimination under Article 100.
Finally, Honorable Dual.
Thank you, Chair. Chair, I support this amendment, but I support it with reservations, Chair. And I take the opportunity, as I support it, to draw attention, Chair, to the very critical challenge where we have, as we list the categories that we are now going to put here, we put women as a category. And, Chair, we give the impression that youth, we do not have women. That disabilities, we do not have women. That minorities, we do not have women. And Chair, I really, as I look at this, I have a heavy heart because I find it extremely challenging that I am seated here, a nominated member that has come under the quota of women in the ODM party, by which case, Chair, I actually represent the entire political party of ODM. And when I sit here, Chair, and I speak on issues of the Committee of the Whole House, I do not really think it is right that we would be looking at numbers because every member of Parliament here is representing a constituency that has very many numbers, and they, by their single presence, is the member of Parliament. And Chair, I had sought to come on a point of order, and I know that I would like my colleague, Dr. Oundo, to take note that it is really one of the greatest challenges that led us to introduce in the Constitution a requirement that we do not bring cultural lenses that would seem to reduce and demean those who are in Parliament. Chair, I do not think that it is right for us, as we deal with legislation in the Committee of the Whole House, that we will be burdening the honorable members of Parliament who are women, even if they are not representing women interests, and continue, instead of dealing with the amendment, to keep making it look like they are not here. And Chair, I therefore say that I support this amendment, but I support it with reservation. As I had said earlier, the manner, Chair, that we are using special interest is suspect, and I hope that as we continue to go, because we have room to continually and to later on do the amendment, I would like, Chair, later on to address this so that we can see that women are not a category of their own, because we have youth who have girls, we have all the other categories.
Honorable Dual, I agree with you, and I would like to affirm what you have just said, that in this House, whether the member is nominated or whichever route they got here, they are members of the House, and there is no member who is less than the other or more than the other. So I will affirm that, and I affirm that. Honorable members, honorable members, I propose, honorable members, I put the question that new clause 16A be now read a second time. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it. I propose a question that new clause 16A be part of the bill. Will as many as, honorable members, I will put a question on that as well. And I'll put the question that new clause 16A be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Schedules, first and second schedules.
Honorable members, I propose a question that first and second schedule be part of the bill. There are no amendments to that. I therefore put the question that first and second schedule be part of the bill. Will as many as are of that opinion say aye? Will as many as are of a contrary opinion say nay? The ayes have it.
Clause 2.
I propose a question that clause 2 be part of the bill. Honorable Jeremiah Kenny, you have an amendment to clause 2?
Yes, Mr. Speaker, I propose that clause 2 be amended as per the bill, and we are deleting the mandate of the, that is clause 2C. We had included the mandate of GEC, and that mandate was going to interfere with the mandate of IEBC.
Honorable members, I propose a question that clause 2 be amended as proposed by Honorable Kioni. I will put the question that clause 2 be amended as proposed by Honorable Kioni. Will as many as are of that opinion say aye? Aye. Will as many as are of a contrary opinion say nay? The ayes have it. I now put the question that clause 2 as amended be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of a contrary opinion say nay? The ayes have it.
Title.
I propose a question that the title be the title of the bill. I put the question that the title be the title of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 1.
I propose a question that clause 1 be part of the bill. No amendment to that. I therefore put the question that clause 1 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it. Honorable members, we are done with that bill. We get to report the mover of the bill.
Mr. Chairman, as I move, let me remind the good professor that it doesn't matter the number of people she was nominated to represent, she has only one vote. But, Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the representation of special interest groups, laws, amendment bill, National Assembly Bill number 52 of 2018, and its approval thereof with amendments.
Honorable members, I put the question, which is that the committee do report to the House its consideration of the representation of special interest groups, Laws Amendment Bill, National Assembly Bill number 52 of 2019 with amendments. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Honourable members, can we have the chairperson reporting, to move the reporting? Chairperson? Give it to the chairperson. We must thank you for your good work. Chairperson, please move the reporting. Yes, the first one on the President's recommendations to the law of contract. Chairperson, conducting the committee of the whole, please use, yes, Honorable
Honorable Speaker, I beg to report to the report that the committee of the whole House has considered the President's recommendation to Law of Contract Amendment Bill, National Assembly Bill number 1 of 2019, and its approval thereof without amendments.
Very well. Can we have the mover to move the agreement with the report? The mover to move agreement with the reports. Thank you.
Thank you, Honorable Speaker. Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also request Honorable William Cheptumo to second the motion for agreement with the report of the committee of the whole House.
Honorable Cheptumo. Honorable Cheptumo, use the next mic. Yes, you have it.
Madam Speaker, I second.
You do second. Order, order. This member. Order, honorable member. It's a long term members. Honorable members, I propose the question for adoption, which is that the House do agree with the committee in the said report. From why I sit members, I'm not in a position to put the question pursuant to our own standing orders. So I will defer putting of the question to the President's recommendations to the law of contract amendment bill, National Assembly Bill number 1 of 2019. So ordered. Can we move to the next one? The chairperson, we are on the representation of special interest groups laws amendment bill, National Assembly Bill number 52 of 2019. Chairperson. To report to the House. Chairperson.
Honorable Speaker, I beg to report that the Committee of the whole House has considered the representation of special interest groups laws amendment bill, National Assembly Bill number 52 of 2019 and approved the same with amendments.
Very well, Honorable Mariro, the chairperson. Can we have the move of the bill to move agreement of the reports? Mover of the bill. Mover of the bill. Honorable
Thank you, Madam Speaker. I
Kioni.
beg to move that the House do agree with the committee in the same report and ask Honorable Roach to second the motion for agreement with the report of Committee of the whole House.
Very well. The mover, Honorable Lodge, to second.
Madam Speaker, I second.
You do second. Oloch is a member for Madare. Honorable members, I propose a question for adoption, which is that the House do agree with the committee in the said reports. Again, cognizant of our own standing orders, honorable members, and following the procedure of the House, I'm not in a position to move to the next step, and I do order the next step of the bill be done in the right time, as it will be stored on order paper. Next order.
Order number 12, motion, annual reports on the state of the judiciary.
Order number 12, the chairperson, Department or Committee on Justice and Legal Affairs, to move the annual reports in the state of the judiciary. Chairperson, Department or Committee on Justice and Legal Affairs, to move.
Thank you, Madam Speaker. Madam Speaker, I beg to move that the House move and notes the annual reports on the state of the judiciary for the financial year 2016-17 and 2017-18 submitted to the House pursuant to the provisions of Article 234, sub-Article 1 of the Constitution, and adopts the recommendations of the Departmental Committee on Justice and Legal Affairs as contained in the reports of the committee laid on the table of the House on Thursday, May 9th, 2019. Madam Speaker, the annual State of Judiciary Administrative Justice report is prepared pursuant to Section 5, subsection 2B of the Judicial Service Act of 2011, which requires that the Chief Justice to submit to Parliament a report on the state of the judiciary and administration of justice for consideration and adoption by this House. Madam Speaker, the Committee on Justice and Legal Affairs considered the annual state of judiciary and administration of justice for the year 2016-17 and 2017-18 and tabled the report. It is this report, Madam Speaker, which is now before the House for consideration and finally adoption. Madam Speaker, the two reports for 2016-17, 17-18 were considered by the committee concurrently in order to save time, resources, and to avoid duplication of efforts. So, Madam Speaker, what we did was to deal with the two reports concurrently because of what I've said. And Madam Speaker, what I will do as I move this motion is to, in a summary, be able to capture what is contained in the two reports so that now members can be able to even contribute more. We have been able to table the report before the House. They are already in the table office, and I believe members really had time to secure copies and be able to really understand the entire reports because they are very exhaustive and they have a number of chapters, Madam Speaker. Madam Speaker, the two reports in summary, indicates the progress made by the judiciary in its transformation agenda as part of the ongoing implementation of our new constitution of 2010. It also records the achievements and the challenges experienced by the judiciary in the financial year 2016-17 and 2017-2018. And Madam Speaker, let me inform the House that in 2016-17, the judiciary witnessed the leadership transition. This is now when we had a new Chief Justice and the Deputy Chief Justice. That was done in the year 2016-17, when we had the change of leadership in the judiciary. It's important to really know that position, because that is the time when we had a new leadership in the judiciary. 2016-17 also, Madam Speaker, witnessed the launch of the strategic blueprint of the judiciary, entitled Sustaining Judiciary Transformation, Service Delivery Agenda 2017 to 2021. Again, Madam Speaker, that is a very important point to note, that this is also the time when judiciary was able to launch a strategic blueprint that was able to guide the operations of the judiciary in terms of the transformation agenda that they were beginning to implement our new constitution. Madam Speaker, the new blueprint strategy shifted focus away from the institutional capacity building approach to service delivery. Madam Speaker, over the years, the focus in the judiciary has been doing a lot of institutional capacity building, but now the new approach was on service delivery. Again, it is important for members to know that point. The new strategy is anchored on 5 thematic areas, and I just want to very briefly, Madam Speaker, mention those for the sake of members. That is access to justice, reduction of case backlog, leadership and good governance, restructuring and strengthening the office of the ombudsperson, and enhancing the ICT infrastructure of the judiciary operations. So, Madam Speaker, those are the thematic areas that this blueprint strategy of the judiciary is focusing on. And when that is done, therefore, it will really deal with the issue of shifting the focus from institutional infrastructure to service delivery. Madam Speaker, the 2016-17 report, if I may just quickly mention, are 7 chapters, while the 2017-18 report has 10 chapters. Madam Speaker, since members will have a chance to refer to the report, I will just say that those chapters that are contained in both the report of 2016 and 17 and 18 and 19 are basically the following: leadership and management, access to justice in the courts, and access to justice in the tribunals, jurisprudence, human resource management and development, finance infrastructure, state of the agencies, and cooperation in the judicial sector. All these, Madam Speaker, are covered in the 2 reports, and it is important to note that. However, there are only 2 chapters that are not areas that are not captured in the 2016-17 report, and that is now obtained in the 2017-18 report. That is on digital strategy of the judiciary and the Judiciary Training Institute. That is the only distinction between the 2 reports, that the report of 2017-18 has 2 different chapters that are not available in the 2016-17 report. Madam Speaker, in the interest of time, allow me just to focus on 2 or 3 areas of the report. As I said, there are 7 chapters in 2016-17 annual report, and there are 10 chapters in the 2017-18 report of the judiciary. Madam Speaker, I just want to focus on one area. Let me start with the area on access to justice. Madam Speaker, the Constitution of Kenya 2010 ensures and guarantees that every Kenyan should have access to justice. And Madam Speaker, justice delayed is justice denied. And therefore, in fulfillment of its constitutional mandate to dispense justice, judiciary has put in place an elaborate policy, legal, and administrative framework to facilitate access to justice. And Madam Speaker, I just want to inform the House of a picture that when we all listen will actually shock us. Madam Speaker, in 2016-17, 344,180 cases were filed, out of which 304,182 were concluded, which translates to an overall efficiency of 88%. In 2017-18, just to do a comparison of the 2 years, 402,243 cases were filed, out of which 488 cases were concluded. Madam Speaker, the cases filed rose from 344,180 in 2017-16 to 4,002,347 in 17-18, which is an increase by 15%. So that, Madam Speaker, between by the close of 2017-18, the cases filed in our courts had increased by 15%. And that, in my view, one can argue and say it can actually be said that it confirms the confidence that Kenyans are beginning to have in our courts, given the reforms that has taken place. Madam Speaker, the total number of pending cases rose by 4% from 350 cases by the end of 2016-17 to 553,187 cases by the end of 2017-18. Madam Speaker, again, I said justice delayed is justice denied. As we go by, the number of pending cases keeps on increasing from time to time. And I think it is something that, Madam Speaker, should worry this House. And us as leaders, we should be worried about the fact that now, every other year, we have increased the number of cases which are still pending, the so-called backlog of cases. It is observed from the two reports, Madam Speaker, that the majority of the pending cases are in the magistrates' courts, which is 74%, and High Court 18%. So, Madam Speaker, it is important to note that most of the cases which are pending, most of them are in the lower courts, that is the magistrates' courts. Out of the pending cases, 205,762, which represents 55%, were aged 1 to 3 years. Madam Speaker, you are talking about the period of time these cases have been in place. That is 1 year to 3 years, you are talking of 55%, which is 205,762. 84%, 671, representing 23%, is between 3 and 5 years. And 82,495 cases, representing 22%, were over 5 years. So, Madam Speaker, you realize what judiciary has done is they have been able to categorize these cases 1 to 3 years, 5 years, 3 years to 5 years, and then from 5 years and above. And you can see the statistics that are very, very scaring, Madam Speaker. So, Madam Speaker, as I said, that because of this, therefore, effective administration of justice requires strategies beyond the courtrooms. And, Madam Speaker, from the reports, the committee observes the following areas. And this, Madam Speaker, what we noted as a committee, because we had a whole, I think, a whole retreat for 3 days with the judiciary staff, the senior staff of the judiciary. And we were able to make the following observations, Madam Speaker, in terms of this particular area. That there is lack of statutory and policy documents providing for timelines within which cases should be heard by the courts, and an adequate number of judges and magistrates were major factors contributing to the case backlog in the judiciary. Madam Speaker, we don't have a law, a policy, that makes it mandatory for judiciary staff, the judges or the magistrates, to conclude a case within a specified period of time. So it takes as long as the judge or the magistrates would want to really take. We are saying, an observation we have made is there is lack of statutory and policy timelines, and we'll be making recommendations on that, in that regard, Madam Speaker. Delayed conclusion of court cases was frustrating to litigants and hampered economic growth as it leads to project stalling, funds being held up without use, and discouragement to potential local and foreign investors. Madam Speaker, another dangerous trend which is now coming again is that when cases remain pending for long, litigants, Kenyans, businessmen, investors, locally, abroad, cannot be able to enjoy the fruits of their investments. Because our case goes to court, Madam Speaker, it takes 5 years, 6 years, 7 years, and you can see the number. It is really scary. So even as a country, noting that the region, in this region now, Kenya is really one of the countries that is doing well in terms of business, these are some of the areas that are really frustrating that particular achievement of us as a country. And that is why you find other investors are actually going out of our country to go to other regions where they speed up conclusion of cases. Another observation, Madam Speaker, is that while several cases were determined on merit through various measures derived and employed by the judiciary, several other cases were dismissed for want of prosecution as part of the strategic deployed by the judiciary. There are also cases where litigants file cases and they don't pursue. And what judiciary has done is they have been able to dismiss some of these cases so that they reduce the backlog, so that you proceed with the cases where the parties in those suits are ready and willing to proceed. Whereas, again, Madam Speaker, I'm just looking at the observations that we're able to really come up with when we were having sessions with the judiciary staff. Whereas mobile courts were necessary in the reduction of cases backlog, inadequate funding of other government agencies like the Office of the DPP hampered their operations, thereby making achievements of the desired results difficult. The judiciary has embraced alternative dispute resolutions mechanism and relied out of court settlement, and that has been able to also help in reducing the cases. Madam Speaker, there are so many observations we made. Let me now look at the recommendations we made in this particular area. One, that the judiciary should propose legislation for enactment by the House, providing for statutory timelines within which cases should be heard and determined by the courts. Madam Speaker, as a committee, we have already engaged the judiciary, and we should be able to come up with this law so that we have specific timelines. And I think it is going to help in reducing the backlog of cases. The National Assembly and the National Treasury should allocate adequate resources in the judiciary to employ more judges and magistrates for the expeditious determination of cases before the courts. Madam Speaker, if you have this number of cases and you don't have enough judges or magistrates, definitely, even the policy we are putting in place again will still be frustrated. And therefore, it is important for this House, under our constitutional responsibility, to ensure that we allocate sufficient resources to the Treasury. The judiciary should increase the jurisdiction of magistrates to deal with matters currently preserved of the High Court, which would significantly reduce the backlog in the High Court. And finally, as a recommendation, the judiciary should, as a matter of urgency, submit to the National Assembly for approval rules to operationalize the small courts claim of 2016. So, Madam Speaker, those are the recommendations that we have been able to make with regard to the access to justice, being a very important area of this report. Madam Speaker, the resources that we have been allocating to judiciary has not been enough. And allow me, Madam Speaker, just to show and to demonstrate to the House, and that is why we need to move with speed. The other area I would like to look at, Madam Speaker, is the funding of judiciary. Judiciary continues to suffer serious underfunding. In 5 successive financial years, Madam Speaker, judiciary has been underfunded. And let me just mention a few. Financial year 15-16, they requested for 26 billion. They were allocated 14 billion. Shortfall, 12 billion. The following year, 16-17, they requested for 23 billion. They were given 17 billion. Shortfall, 7 billion. 17-18, 32 billion. Given 14. Shortfall, 18 billion. 19, requested for 23 billion. Given 15. Balance 13. And finally, Madam Speaker, again, 19-20, which is this particular financial year, 38 billion requested for. They were given 19 billion, balance of 19 billion. So, Madam Speaker, it's so clear that for the last 5 successive financial years, judiciary has been underfunded. And yet, Madam Speaker, we still expect the same judiciary to provide access to justice to the Kenyan people. It is not possible, it is not tenable, and we must be able to do something on this. Madam Speaker, and I am happy members of Parliament are here, and because of that reduction in terms of the allocation, we have had serious delays in construction and completion of courts. Madam Speaker, we need 2.1 billion Kenya shillings now to finish 23 courts across the country. Oma Bay, where Milo Thiambo comes from, there is a court which is pending there. It's not being completed. It is in your constituency, yes? Gabarnet.
Order. Honorable Emilio Odhiambo, even when you are mentioned, you don't need to shout from where you sit. You should appreciate that he has mentioned you and allow the other members appreciate. Of course, they just appreciate.
Okay, Madam.
Emilio Odhiambo Bona. But you don't need to shout on Emilio Odhiambo.
We have Gabarnet, Marsabit, Amagoro, Kithongo, Kandara, Machakos, Kiambu, Bita, Embu, Muranga, Eldoret, Garsen, Odhaya. Madam, it's a long list. They are at some stages of completion. We are unable to move because there's no money. So, Madam Speaker, these are some of the challenges that I just wanted to bring out very, very clearly before this House for them to really understand. Compliance with the Article 173, we are now trying to look for the solutions. How do we really resolve this issue of underfunding of the judiciary, Madam Speaker? Because every year we have this problem. As a committee, Madam Speaker, and this is a very important issue we need to raise, we want to propose as a committee, Madam Speaker, that if we implement the provisions of Article 173 of the Constitution on the judiciary fund, then, Madam Speaker, judiciary can now be independent, can have funds that is able to function. Madam Speaker, just allow me to refer to this article because it's very important. 173 of our Constitution, Judiciary Fund. There is established a fund to be known as Judiciary Fund, which shall be administered by the Chief Registrar of the Judiciary. The fund shall be used for administrative expenses of the judiciary and such other purposes as may be necessary for discharge. But let me go to the relevant section, Madam Speaker. Subsection 4. On approval of the estimates by the National Assembly, the expenditure of the judiciary shall be charged on the consolidated fund, and the funds shall be paid directly into the judiciary fund. Madam Speaker, this is not an optional position. This is constitutional. It is for us. And I want to report to the House that already the Judiciary Fund Act has been passed in 2015 by this House. The regulations that is supposed to actualize that law, Madam Speaker, is in the process of being approved by this House. And I'm happy my colleague, Honorable Murugara, is a member of the delegate legislation, and he will be seconding this motion, and I believe he will mention to us if they have been able to go. If we succeed in this, Madam Speaker, and we must succeed in this, then I think now the judiciary, once given their money, should be able to actualize that money, spend it without being subjected to supplementaries. Like now I'm told we are preparing for another supplementary too, which is likely again to affect the very allocation that has been given to the judiciary. And so, Madam Speaker, that is an area we propose again in our report that we need to actualize Article 173 of the Constitution. Meanwhile, as we do that, Madam Speaker, National Treasury should ensure timely disbursements of exchequer to the judiciary and other agencies to ensure timely undertaking of projects to avoid possible litigation and escalation of costs as a result of delay. Madam Speaker, we have the IFMIS business. The other day, before the supplementary one was done, you saw and you heard the Chief Justice coming out very strongly and complaining that the exchequer is there, but the releases are actually delayed because of the IFMIS process. We want to propose that this is an area where we need to deal with, and the solution is Article 173. So that, Madam Speaker, the IFMIS thing where you control and you manage judiciary should be something of the past, so that they have their money, they do their work timely, pay the suppliers, pay the contractors to avoid, like now, Madam Speaker, we are spending a lot of money in terms of delayed payments of bills. Madam Speaker, I know I have taken a bit of time, but it is because of the fact that this is a very important area. And Madam Speaker, let me say this as I conclude. As the chair of Justice and Legal Affairs Committee, and I've said this in the presence of the Committee of Budget and Appropriations. Madam Speaker, when you talk of allocating money to build houses, you can actually feel, you can see what that money can do. The number of houses, their location, and the value. You can see. When you allocate money for roads, you can see the roads. You identify them. From this point to point A, to point B. When you allocate money to build hospitals, it is clear. But, Madam Speaker, when it comes to justice, access to justice, it is not, you cannot touch, you can't feel, you can't see. But unless and until you face that situation where you need to access justice, Madam Speaker, that is when you realize that we need to have enough courts, we need to have enough judges, we need to have enough magistrates, that we need to have all these things, Madam Speaker. And so I just want to say that as much as we want really to allocate money to deal with security, which is a critical component also in our society, we need to allocate money for housing, we need to apply money for industries, we need to apply money for health, we also equally need to apply money for judiciary so that we access justice. After all, Madam Chair, even when we have a robust economy, the institution that is able to deal with disputes that makes that economy to prosper and move again is the courts. So we may be wanting to grow as an economy, but we realize that we are also being suppressed so badly by the fact that we have systems which are not working in our courts. And so, Madam Speaker, with those, I've just captured only two areas, the areas of access to justice, the areas of funding, the areas of jurisprudence has been done very well. Our courts, Madam Speaker, for the last several years they have been able to set standards and come up with certain positions in law, and we have been able to capture that. In fact, the issue of jurisprudence is captured in a whole chapter of this report, and the others I don't want to. Actually, it is actually from page. In the two reports, we have a whole chapter on reports on jurisprudence, what our courts have been able to do over the years. And we have been a country that we have been able to even be quoted in other jurisdictions. Madam Speaker, recently, when there was the case when the elections in Malawi, when they went to court to challenge the presidential elections in Malawi, I was told by a friend who lives there that Kenyan case, you know, the recent election petition by the NASA was quoted extensively in Malawi, and finally the results were actually reversed were nullified. What does that mean? Madam Chair, this country is a force in the region. All we need to do is to put our house in order. Let us ensure that we don't underfund certain areas which are critical also in enabling our economy to flourish and to grow. Madam Speaker, with those remarks, it is now, I move and I request that let us, as a House, adopt these reports, 2016, 2017, and 2017, 2018 annual judicial reports, and it's going to help this country because then they are able to implement their recommendations of this House, and it's going to improve our judicial system, and we are going to have a better environment for our businessmen, for our investors, and it's going to benefit even our people, young people who don't have employment, because therefore there will be space now for more jobs for our young people. Madam Speaker, I beg to move, and I want to request Honorable Murugara, who is also a member of the committee, to second, and Madam Chair, Madam Speaker, I move.
Very well. Thank you, the member, the chairperson, Department Committee on Justice and Legal Affairs. Then we have the Honorable Mugabe to second.
Murugara. Thank you, Madam Speaker. Madam Speaker, before I move to second, I've just spoken for the first time this afternoon, and I just wish to take 1 minute to condole with the people of Msamweni for the loss of their Member of Parliament, the late Honorable Suleiman Dori. On my own behalf, on behalf of the people of Tharaka constituency, Tharaka Nithi County, I do relay my very sincere condolences to the family and to the people of Msamweni, and that is Kilifi County. It's Kwale County. Thank you. Madam Speaker, allow me to second that this House notes the two reports of the state of the judiciary and the administration of justice, and also adopts the two reports of the Committee of Justice and Legal Affairs regarding its analyzation of those reports. Madam Speaker, these two reports are a first of a kind because the judiciary has not been tabling these reports with the Parliament, but pursuant to the provisions of the Constitution and the Section 52B of the Judicial Service Act, this has now been done, and it does rhyme very well with what the executive does every year in a ceremony presided over by His Excellency the President, coming to Parliament to address Parliament on the state of the nation in his annual address to the House and to the nation. I would draw a parallel that Parliament too should actually copy these two institutions, because this is the process of checks and balances. This is how one arm of the government checks the other by ensuring that it is reporting to the other what it is doing and justifying its existence, especially when it comes to budgeting. So I do not know, but it's for debate, it's moot today, how Parliament would actually report to the rest of the country, as we did once a while ago, but unfortunately we cannot debate ourselves, and the debate for what we are doing, once it is given to the country, will have to be done elsewhere. Be that as it may, mine would be to urge the judiciary to use one of the best institutions it has, the Judicial Training Institute, which rivals only the Government Training Institute at Kabete in terms of its ability to train officers. If the judiciary does make maximum use of this, we are likely to get better quality of judges, magistrates, and staff. The Committee on Justice and Legal Affairs deliberated on these reports, and it has made several recommendations, which members will have to read from the reports. And also, it is important to note that these reports are elaborate. I mean, one of them has 7 chapters, the first one, 2016-2017, while 2017-2018 has 10 chapters, all dealing on matters of interest to this country when it comes to matters of legal affairs. We have made several recommendations, and these are all in favor of enabling the judiciary to function well. It goes without gainsaying that a country governed by the rule of law must have a robust judiciary. There is no way the rule of law can be enforced in a country unless it has a judiciary that is not just competent, that is not only independent, but which is also corruption-free. Because what else our judiciary, most of the time, is or are allegations of corruption. That we are not doing what we are supposed to do unless there are external influences that render the decisions that the judiciary makes. It is important that we enforce our constitution, which sets the judiciary fund. It has been dead law for a long time. We have enacted the Judiciary Fund Act. We have actually passed the regulations thereunder, but even up to now, that fund is not working under the Public Finance Management Act. The reasons we are given is that the consolidated fund is not able to remit the money immediately because most of the time we budget on monies we do not have. We budget on monies that will be collected by the taxman, or we hope to borrow, or we hope to get grants. And therefore, upon passing of the budget, there is no money to transfer. But I think it is a high time we started living within our means and budgeting on the money that we have so that we are able to carry out the obligations we have under the law. So we need to operationalize that judiciary fund with immediate effect so that we do not have the Chief Justice, the Chief Registrar of the courts, or any other person crying out there to the media, seeking sympathy from the public, that they do not have money because they are not able to function. And especially in Kenya, where we have a monster known as IFMIS, which is anchored in the treasury, which releases money to you as and when they feel like doing it. That is not acceptable, especially when it comes to an independent arm of the government that needs direct funding from the consolidated fund to its own treasury. So therefore, we do urge that the exchequer is timeous, money is released in time. We also urge that the courts must ensure that they do their work properly in such a way that we make it a law or a provision that court fines, court fees, and the forfeitures that are done by the courts are actually used at source. Once we do this, then we expect the judiciary to move the speed and complete its projects. We have many stored projects, as it has been said. I actually have a court in the Raka constituency at the headquarters at Marimanti, which was started as a wooden court. It has never been completed. It has never been used. Whenever I meet the judiciary, whenever I meet the Chief Justice, I muse that he made a provision for fodder, for termites and ants, because that is what is happening. Lots of money that possibly is going to waste, but the cited reason is that there is no money to complete. We would also want to deal with the mobile courts. I also have a mobile court that serves from Marimanti to a place 45 kilometers away called Kavangachini, and there is no way justice can be dispensed when that court is mobile only once a week. Sincerely, nothing much can be done. Again, we need to look at this. The other problem we had were title documents for the courts, and it is encouraged that courts must have titles. The judiciary must be the custodian of its own property and land. We have had instances of grabbing, where court land is grabbed, and the judiciary goes to fight, possibly fighting even in its own courts. And again, this cannot be encouraged. But we must also say that once we give the judiciary the resources, there must be expeditious disposal of cases. The chairman has elaborated very well that what we consume from the judiciary is not visible. It is only inherent. It is only felt. The consumer of justice is the only person who knows the value of that justice. Therefore, we need to see cases moving fast so that we do not go to the Environment and Land Court today to take a hearing date, and you are given a date in September next year. Sincerely, I do not think any proper court, any court that is dispensing justice, can give a date today, sometime next year. This is not expeditious. It should not be encouraged. Number two, there must be means and ways of ensuring that there is no corruption in our courts. We must fight the corruption to ensure that judges are cleaner than Caesar's wife. The justice they dispense is what everybody believes in, because justice that is obtained through fraud, through corruption, through any other means that is extrajudicial is not justice. It cannot be trusted by anybody, and therefore that erodes the confidence in our courts. With those remarks, I do support that this House does a note, the two reports, and I also do support that we actually adopt the reports. Thank you, Madam Speaker. I do second.
You do second, and a very worthy member for the RAC. Honourable members, I propose a question, which is that the House notes the annual reports on the state of judiciary for the financial years 2016-2017 and 2017-2018, submitted to the House pursuant to the provisions of Article 2541 of the Constitution, and adopts the recommendations of the Departmental Committee on Justice and Legal Affairs as contained in the reports of the committee laid on the table of the House on Thursday, May 9, 2019. Honourable members, the floor goes to the first honourable member on my request list, that is the member for Suba North, the Honourable Millie Odhiambo Mabona.
Thank you, Madam Speaker, for giving me this opportunity. And Madam Speaker...
And allow me note that you are a lawyer, and now that we are discussing issues of the judiciary, the member should be ready for your good contribution.
Yes, thank you, Madam Speaker. And Madam Speaker, I just wish to thank the Committee of Justice on their report, and I do support that the House notes the two reports of the state of the judiciary and administration of justice of the years 2016-2017 and 2017-2018. And I want to thank the mover and the member for Tharaka, especially on emphasizing the need for separation of powers that ensures that the three arms not only support each other but oversight each other. And Madam Speaker, because of time, I'll try to be very, very brief. And just note that based on what the committee has said, I wish that the committee had focused a lot more on the issue of corruption. I know that there was a time that there was a purge that was done in the judiciary and that restored a lot of confidence in the judiciary. But there is increased cases that are being reported of corruption in the judiciary, and for the public to have confidence in the judiciary, especially when you are having trying times both in the executive and the parliaments, when the public confidence in both institutions is not very high, then you at least need one of the government where the public has a lot of confidence. Madam Speaker, I remember the time when we had Justice Mumbi in charge of a human rights court. People had a lot of confidence in that court. I'm not saying the justice that is there is not doing any good job, but we had justices that are very brave, and that is something that I can talk to, not just the issue of independence, but jurisprudence that they have alluded to, that even for us to be able to get solid jurisprudence in Kenya that people are emulating, including Malawi, it speaks to the independence of our judiciary. And that is why, as Parliament, we must make sure that we do everything possible to shield the judiciary, especially through budgetary allocation. I know that I sit in budget, and it is something that we have had to discuss as budget, and we bravely made certain provisions. But then again, we have challenges when you come sometimes to the floor, and then amendments are made that then takes back the kind of brave steps that we have taken as a committee. So I would want to encourage the floor that we need to be brave enough to give the judiciary the confidence that they need, because part of that independence is that they have their own allocation. That's part of the reason that even Parliament agitated for their own funds. Because if you don't have independent funds, it becomes very difficult to be independent, especially when you rely and you are being given provision like Panadol. And we would not want a situation where the Chief Justice and the other judicial officers that we should be having confidence in are the ones that are complaining before the public that they are not being treated well. I want to confirm that indeed, as the mover was mentioning, the courts that have not been completed, part of the 23 courts that have not been completed, one of them is the Mbita Law Courts. Currently, the courts that are serving Mbita is mobile, that are using the probation office, which is right next to my parents' home. But the actual court should be in Mbita town. And in fact, now it's beginning to have wear and tear, which means it's a lot of the money that has been put into it is going to waste. And I would want to urge that as a House, we need to be brave enough, complete the 23 courts so that we can enhance access to justice. And you can actually see the immediacy in terms of access to justice, because cases of insecurity are on the rise in my constituency. That has been a haven of peace, that you could sometimes, when my other colleagues visit, they can't believe that you find cattle just lying on the roads. Nobody is bothered, nobody steals. But now cases of insecurity are on the rise, and our courts don't have the capacity to deal. And I would want to also say the cases of sexual and gender-based violence are also on the increase, and we need the courts to be able to host judges and magistrates that are of a higher jurisdiction, Madam Speaker. Madam Speaker, again, if I want to speak to the issue of backlog, and Madam Speaker, unless we as a Parliament are able to give those resources, then we will not be able to deal with backlog. And again, justice delayed is justice denied. Madam Speaker, one of the things that I've noticed in the report is that it focused on the issue of institutional capacity in the first financial year, but in the next phase, it has focused on service delivery, which is a good thing. But I would want to encourage that we should not lose sight of that institutional capacity that also entails building the capacity of the judicial officers. Why am I saying this? Madam Speaker, there is a growing concern about the decisions that are emanating from the courts in relation to especially not maintenance, but child custody, that seem not to follow non-legal standards. I don't know what's going on, But I think that is something that needs to be looked at, because if the judiciary doesn't even have the capacity, or the senior officers don't have the capacity to monitor the jurisprudence that is coming from the various courts, then you'll have a case like one that was cited today, where a mother has been given 9 days in a year to access the child. Which mother can have 9 days to see their child? And if we are not able to balance the way we are dealing with these things, and we'll be seeing many calamities, because people will be taking the law into their own hands. So I think as Parliament, again, we need to look at that. And speaking on issues even of access to justice, if we are not able to facilitate the judiciary, in my own constituency, even if you don't talk about the court that I'm talking about in Beta Law Courts, we have several islands that actually need mobile courts, and that is a resource in itself. So before we even talk about this completed court, how do the courts reach the other areas where they need the boats and all that? And that is why, again, a lot of cases of sexual violence are not dealt with, because people would rather deal with them at their levels. I would want to encourage the committee that you have talked about the need for policy on timelines for completion of cases to enable to deal with issues of the backlog. But I would want to place caution that we should not actually sacrifice justice at the altar of expediency. And sometimes it's, as my good colleagues know, sometimes it's not just the judges, but the advocates and the litigants themselves who will get excuses to delay cases, who will get excuses for their matters not to proceed, especially when they think that the decision may not be favorable to them. But when we actually provide a policy, and I know this is a challenge that the judiciary itself has had to grapple with, is that when you provide a policy and say that these cases have to be dealt with by this time, then the persons that will likely to suffer, especially in criminal cases, are the victims. Because then if I am a perpetrator, I will just delay, knowing that at the end of the day, if the time comes, then I will be acquitted because of no-show. I am actually surprised that the small claims court had not been operationalized. I'm learning about that right now. And I would want to urge the Justice Committee to take this matter up very seriously, because it would help to ease the congestion in the courts by freeing the courts of the smaller cases that are there. Madam Speaker, one of the things that I would want to say is also that I want to laud the judiciary on some of the decisions that have come up. Madam Speaker, I can see my time is up, but I just want to say, I know that, for instance, Justice Martha Koome recently made a very good decision on equality. And Madam Speaker, people always think that when we talk about gender equality, it's only just about women. But in this case, she actually made a decision that was favoring men, because equality is not just about women. But in a situation where you find that the woman is working and the man is not working, the man needs support just as much as the woman does. And I think for us as women, we need to understand that equality now has to do with taking care of both men and women. It's not just about women. With those few remarks, Madam Speaker, I support. Thank you.
You support. Thank you, Honorable Emilio Odhiambo, being a senior member of the House and, of course, also a lawyer. I think as a House we are well informed. Honorable members, I must appreciate that I have several members who are requesting to speak to this, and allow me. Oh, is this member? Very well. Allow me announce that in the next sitting, as the motion will appear in our order paper, we'll have several members and others making contribution to this. Honorable member for Dikiri, Kilifi North, Kitui Central, Kinyanga Central, Kirinyaga Central, among the many members who want to contribute to this. From the Speaker's desk, we still have more time to debate on this. And there has been a house of procedure. Members, the time being 7:01 p.m., the House stands adjourned till the Wednesday, 11th day of March 2020, at 9:30 a.m. We thank you all.